your role as a researcher while we are translating the idea into the innovation. And while we are trying to learn this, it is important to learn about the macro vision, which through which entire ecosystem is working. See, in entire knowledge economy, there is one end an industry's interests. On another end, there is a IP policymakers priority, and in between this, researchers are there. So industry would like to have a new knowledge which is accessible to the commercial benefit, and by pr- utilizing this new knowledge, they would like to earn high profit, high return and consistent return on investment which they can offer to their shareholders, and a sustainable growth. And by doing this, they would like to achieve the nation's economic goal. On another end, policymaker, thinkers, and the government has a priority that if we take the example of a healthcare, we all have seen the COVID-19 pandemic situation. So what was the government's priority? Government's priority was to offer affordable medicines, accessible healthcare, and the classic vaccination drive, vaccine availability, vaccination drive, which government has initiated, is important in achieving the nation's social goal. So on one end, there is an industry interest. On another end, there is a policymaker's priority, economic goal versus social goal. So churning between both the side, the manthan which is happening, this manthan is going to result into the improved IP regime. And as a result of improved IP regime, we are going to have innovations, better and improved processes. And classic example I would like to take that before COVID, pre-COVID era, we were net importer of a ventilator, which was costing around, say, as a 25 to 30 lakhs. And during the COVID-19 situation, this challenge was taken up by the youth and the researcher creators. And they have created a novel design of ventilators. And this novel design has reduced the cost, regulatory optimization, novel designs approach was accessible, and access to the industry for producing this. Many corporate group who were not producing their traditional product, their engineering lines, they have dedicated to produce the ventilators. So this change we have never seen, but with a mission to fulfill the need of a country. And that, when somewhere the challenge is, we are always going to align entire resources. And COVID-19 has taught us this. IP creation from idea into the action was there. We have started with the problems, we have discovered where the solution is, and from the available options, we have sharpened the entire strategy. Strategic initiative, we have then prioritized what is our top priority. Top priority was a ventilator. Then we have also optimized the PPE kit, which was a net import in the pre-COVID era. Then we have ensured that medicine, vaccine, all this we have in a phase-wise manner prioritized. So while translating idea into the invention or into the action, we have to set the priorities. And this is not just at a macro level. This is equally applicable at your institutional innovation council level as well, at your R&D level, at your institute level, at your university level, within your research group as well. We might be identifying a research problem, but what is the relevance of this research problem from the commercial perspective, from the applied perspective, from offering the benefit to the society? Have we ever thought while defining the research problem for our doctoral studies. We may not be having this idea, and we might be producing a PhD which is not resulting into any improved knowledge which can be deployed for the societal benefit. So that's why this lecture is important. What as a researcher we have to do while we are translating the idea into the invention, and this invention is put it into the action. And while we are trying to achieve this, we need to keep three things in our mind, which are a game changer uh, pillars: research, innovation, and technology. Research, in which area we should conduct our research. Innovation, whatever the innovation which we are trying to explore, whether this innovation is commercially viable or not, legally protected or not, and technologically advancement is happening into that or not. And while in technology we always measure our technology on a TRL platform, which is a Western platform. In my opinion, the India centric model should also evaluate not just TRLs. We should also evaluate the technology from the commercial perspective and from the societal relevance perspective. And if the legal protection of a IP we want to explore, then let's imagine that we have a tri-leg table. You might have seen the small tri-leg stool in your laboratory. Just imagine that concept in your mind and think that your IP innovation or idea is placed on the top of this table. Now, one leg is science and technology, another leg is a commerce, and the third leg is a societal understanding or relevance to this IP innovation. Imagine if any one of the leg is weak, what is going to happen? What is going to happen to the idea, IP, or even the commercial innovation? Entire chain I am putting on the top of this table so that you can imagine how much importance it is. And while as a researcher you are translating idea into the invention, you need to keep all these points in your mind. Whether your idea is placed on a table, whether your IP, which is protected through a legal IP tools which is accessible to you, or innovation. Invention is translated into the innovation through a proper systematic technology transfer and offered the commercially sellable product. So at any stage, from idea to IP to invention, invention to the innovation, in entire value chain, if any of this three leg is weak, the idea, IP, invention or innovation which is put on the top of the tri-leg table, if any one leg is weak, what is going to happen? Have we ever thought on those lines? That's why sooner is the better to learn adopting this strategic model where you are not just thinking about the technology, the technological advancement which is happening, how far this futuristic technology and its elements are going to sustain. On commercial front, whatever the technology and innovation or even the invention which you are trying to develop, what is cost of this invention? How long it is going to compete with the other product which is already available into the market? If commercial sustainability is not there, then what is going to happen? No matter whatsoever may be the IP innovation which you have developed, if it is not viable into the commercial market, it is going to result into the mortality of your research efforts. That's why we need to understand, evaluate the technology from the commercial perspective as well. The third aspect is the societal aspect. Imagine the technological advancement which is happening. But if this advancement is not resulting any benefit for the society, what will happen to this? And we might have many examples, but I would like to quote a single example. There was a satellite launch vehicle which people were trying to develop, and they wanted to send the humans on a moon or for the livelihood. There was a big ambitious mission, but how far this mission or technological advancement or an innovative concept is going to benefit to the common people? And that's why so much of a billions of dollar which was invested, still the mission is incomplete. We need to explore the IP invention which can benefit to the society. We all have realized that we were not the first people to produce the COVID-19 vaccine, but with the import of this technology or with the retrofit development and the scale up of technology in Indian scenario, we were the largest producer of the various vaccines. At one point in time, we were importing the vaccine, and import was reaching after few years. Here, within 6 months, India has arranged the domestically produced vaccines. Technology was also accessible, and we have scaled up, and we have also done the vaccine diplomacy. So this is the power of invention translating into the IP translating into the invention, and invention into the innovation. The IIT Guwahati based researcher have developed a reagent to develop the paper based COVID-19 detection kit. When entire world was following the RT-PCR, which has the accuracy rate of roughly around 60 to 65%, these paper-based kit reagent were developed by IIT Guwahati-based researcher. They have again translated the idea, put it into the action, and this idea has resulted into the IP into the invention into the innovation in less than a year. So this kind of a rapid transition is required. And we all have seen that how much important this discovery of reagent were. This discovery of reagent was definitely an essential element which has transformed the entire COVID detection, and with the accuracy rate of more than 90%, 95% also. So we need to enable the people to ideate, and we need to empower the lives to adopt this invention. We have successfully adopted several such inventions which were developed by the youth. And that's why IP and youth innovating for the better future is realized by India. And building the new India towards the growing as a developed economy, we need to realize the importance of IP invention and translate the idea into the invention. This is a game changer strategy. I must say that we were discovering several such research. We need to interpret it into the right model which I have explained you, and then put the ideation into the experiment, and experimentation into the evolution of the commercial practice of your IP. This is something where we are going to generate the IP, and this is a classic model which is going to offer you the tri-leg model, which is a similar model which I have explained you. Customer value change which is required into the technological advancement, and research which we want to put it into the action. If intersection is going to result into the innovation, then IP is a small dot out of it. But very important, you need to take care of your intellectual property and protect this. And research and development in a nation building, how your research is going to offer. As a researcher, you need to have the clarity on this. See, on one end, we are trying to work on the basic science or technology, which is going to offer you the advanced knowledge or gainful and useful knowledge. And by doing this, what we are achieving? Creation of a value for knowledge. And then if we are trying to convert the IP into the innovation through a systematic process, so idea into the invention is the approach, and subsequently we are resulting this invention into the innovation, commercially utilizing the IP. So by doing this, country is going to gain the leadership position. And leadership in usable knowledge is essential for our country. And entirely we are going to offer the competition. And we have seen that even though vaccine were produced all across the world, India has done the vaccine diplomacy with 58 countries. It is largely creating new jobs, creation of a knowledge which is on a national priority area. And definitely, as a researcher, what you will personally gain is the knowledge. See, knowledge seeker will also have a pride after doing something for the society, something for the nation building. And to serve the society, we need to utilize the Bharatiya knowledge and the values. And that's why your role is important. We need to learn 4P of innovation: product, process, position, and paradigm shift, which is happening. As soon as you are away from the peripheral things, you are losing the incremental or radical transformation. So you should always be towards the end peripheral electron. Chemistry people may know that what is the peripheral boundary. If you are away from the nucleus, you are radical, you are transformative. You have the advantage of a cutting edge technology. And as soon as you are nearby to the nucleus, you are incremental. There are so many incremental invention, innovation has the importance in society, but commercial gain can best be achieved if you are into the peripheral boundaries. Okay. And traditionally, we always utilize the knowledge. Knowledge management is the power for the Indian ecosystem. Researcher utilizing their knowledge. The 2100 institutions which were part of the Smart India Hackathon, their students are utilizing the knowledge for the challenges which put forward to them. So what they are doing, I'm going to discuss in my next slide what researcher need to do while you have a vision to translate the IP into the invention. And it's a systematic IP strategy wherein you are designing the IP. IP by design is the concept, and it is going to be a mantra for next decade. IP by design. And how you are going to design the IP, you need to learn by systematic approach you are going to adopt in your research. First of all, you need to learn the literature search. Journal research, literature search using the journal references is never going to be the perfect one. Equally, you are required to explore the patented literature, which is also accessible nowadays, and majority of the patent offices have the IP search, patent search accessible to all the researcher without involving any major cost. But once you have to identify the patented literature, you need to learn how to interpret this. It is a techno-legal document. It is in all together a separate lecture is required into this. But wherever you are finding it difficult, you can approach to the Institutional Innovation Council who can guide you, mentor you for this. You will identify a number of patents and how many technologies are reported into these references. So while you want to have some technological advanced solution for a specific problem, you need to scan the literature, jot down how many technologies are known so far, strength and weakness of each of this technology. This is going to help you to improve your knowledge also. And what is the additional use of this technology? So that you can play around it, or you can think out of box to invent some new technology. Who all are the competitor? This result will benefit you in understanding number of patents, which technology, strength, weakness of a competitor. Build your strength and core competencies into the technological advancement. You can also explore the licensing in or licensing out of your IP if you have executed your IP strategy effectively. Licensing out option is wonderful, that will generate a revenue for you. Maybe if you are not willing to license out, there are so many IP creators who have donated their IP. Like one such ophthalmic researcher, he is a seasoned ophthalmic doctor, uh, and then he has developed one unique solution. So earlier, the while we are performing the eye donation, once the eye is required to implant within 48 hours, otherwise this donation is not going to be a useful one. This uh, ophthalmic doctor has developed a solution which can preserve the eye for additional 5 days. So within 1 week, somebody can donate this eye from one individual to another individual. So eye donation has got the improved shelf life using this solution. This is preservative solution and it's quite inventive. And he has dedicated this entire discovery for the betterment and of this eye donation activity. So donation of IP is important. We may not be knowing this researcher, but we can now realize that eye donation can be done in 7 days. So donated eye can be implanted in 7 days. So this is important. Nobody knows this researcher, but people are using this research, and his contribution has the societal value. Many a time, out of foresight, we lapse in maintaining the patent. It is also equally important. So while we have a fair background on technology, its a strength, weakness, additional use, competitor, and various other R&D opportunities which is available on table. It's a powerful searching and patent analytics tool and skill which can develop this, which you as a researcher need to gain. You may not be knowing the bicycle riding when you were into the KG and upper KG and lower KG. But gradually you have learned this bicycle riding. And now at this age, somebody offers you the bicycle, what will happen? You can comfortably ride on the bicycle. Same thing is there for the patent searching or patent analytics. You have to learn. By practice, you will gain the experience and you will develop your niche on this. Your understanding on patent specification interpretation, claim interpretation, which technology is discussed here, and what kind of reagents used or disclosed into the specification. This is again a useful component which can offer a fair amount of understanding for you. So, knowledge is now flooded through this IT revolution. At one point in time, as a IP professor, I would like to mention here that you may have so many references, technologies which is accessible, available, reported into the literature. The second skill which you have to develop is you need to classify them. What do you have and what do you need? Acquire what you need and divest what you don't need, which is important lesson for you to learn as a researcher. हमारे पास कई ऐसे रेफरेंसेस, कई ऐसे लिटरेचर हमारे सामने आते हैं जब हम लिटरेचर सर्च करते हैं। हमें ये सीखना होगा कि क्या हमारे लिए उपयोगी है, क्या उपयोगी नहीं है। जो उपयोगी है उसे आगे ले जाना है, जो उपयोगी नहीं है उसे वहां पर ही छोड़ देना है। क्योंकि इंटरनेट ने आज नॉलेज, रेफरेंस, लिटरेचर की सुनामी कर दी है। सो first of all, you need to learn this, and this will come by experience. At periodic level, you need to also learn the internal IP audit, which is again the advanced level of a skilling. If you want to learn, you need to acquire the knowledge on this. And I'm told that AICTE has also started the IP curriculum, which they are soon going to offer in terms of a add-on course. So UG, PG and PhD students can opt this intellectual property course, wherein all these points are going to discuss. You will be exposed through all this niche parameters which are skill building activities, which is essential. One has to learn what is gap analysis. This gap analysis means somebody has protected their IP or somebody has reported their IP, and there will be several such literature reference. So what is the gap in between? This gap analysis will help you establishing your own goal or idea for fulfilling this gap and create your own IP out of this. And this is a costly affairs. You will also require to learn the investment strategy, development strategy, and all together, right from the top to bottom, it's a IP strategic development. And this is going to help you in learning this. Now, as a researcher, what you want to learn out of this? So, startup and entrepreneurship journey is a passion for the youth, and these are the hotbed sectors which is going to offer you the unique opportunity. And before that, where these people are failing, कहाँ फेलियर है ये हम सीख लें, तो हमें वो गड्ढे में नहीं गिरना है, फेलियर के गड्ढे में हमें नहीं गिरना है। इसीलिए मैं हिंदी में फिर से दोहरा रहा हूँ, शायद ये बात बार बार आ रही है, लेकिन अगर कोई और फेल हो रहा है तो हमें भी निश्चित रूप से फेलियर में नहीं जाना है, हमें उसके फेलियर से सीखना है कि कहाँ वो गलत जा रहे थे, हम वो गलती नहीं करें, where they were failing, and we should not repeat this mistake. As a researcher, this is also important for you to learn. If there is no market, you don't need to invest your resources in developing any such IP. If you don't have a right team, then build the right team to strengthen your foundation. Pricing and cost issue, I have already discussed. Products without a business model, if you are developing without the societal need, so imagine this again correlate with this commercial readiness level, societal readiness level, and the technological readiness level. Globally, only one parameter is getting evaluated. technology readiness level. The remaining two parameter is I have developed when I was part of a GNU. As a professor of IP, innovation and entrepreneurship, I have developed this model wherein along with the technology readiness level, commercial readiness level and the societal readiness level is equally important. One researcher is still working in GNU in this developing this model. So this is so far, I am confident that this is something which is a useful model. You need to learn on about this model. We can have a separate class under this IP course, which is going to be offered by AICT. So you may opt this course and we can discuss further on this. Many a time researchers lose their focus or ignore the customer. They are so passionate about their research, they ignore the customer need. You should not make this mistake. You should have a focus. What is your end delivery? And uh, pivot gone bad. Whatever strategy they have designed, that's not working well. And this strategy will require to work effectively. Okay. And maybe you have failed in understanding the geographical expansion also. So you might have developed a product for Indian market, but you are selling it into the Australian market. You are protecting your IP into the Australian market. Many academic institutions are making this mistake. So I would like to hear, ring the bell for them. Don't waste your money protecting your IP for the registered patent which is filed in Australia. That's not going to offer you benefit any single penny for the product which you want to sell in India. Intellectual property is a territorial right. You need to learn this. And what as a researcher you need to learn, this is important lesson for you. Just for having a patent to your credit which is not even examined by the regulator, you are spending few thousands of rupees in just seeing the bibliography and your name on their database. They are not examining, they are simply putting on their database. So be caution, don't waste your resources like this. Each single penny spent on the IP protection should have a plan, should have a strategy. While you are translating the idea into the invention, every entire step where the IP is involved, you need to have a financial planning of that IP protection also. Apply in India, get your patent registered in India, because Indian patent is going to offer you the IP protection. If the patent is granted, its specification is meeting the requirement as per the Indian Patent Act. And if the claims are not falling into the domain of a non-patentable invention, which is discussed into the section 3 of a Indian Patent Act, then you will be granted the patent protection by Indian Patent Office. Now, filing cost is 1/4 to the traditionally filing cost, which is there. You can get the patent examined and the ultimate result of your patent application in less than 10,000 rupees, which is the official fee. And for that, AICT, TIFAC, NRDC is also offering the financial assistance. If you don't have a 10,000, don't need to worry for that. These institutions are offering the financial assistance to you. So practically, by spending 0 rupees, you can explore applying for your patent in India, and everything is falling in line as per the Indian Patent Act. You will be granted Indian patent that has a value in India. So this is something which you have to explore. Imparting through a skill for tomorrow's education and innovation need is equally important for you. If you don't have a skill, acquire the skill. This is as good as that. Omniscience approach, learn to apply in your developmental leap. आज तक जिस तरह से रिसर्च हो रहा था, उस रिसर्च के की प्रायोरिटीज में, रिसर्च के अप्रोच में, रिसर्च के आउटकम में तीनों जगह पर बदलाव की आवश्यकता है। ये बदलाव आप ला सकते हैं। इसलिए आज वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी डे पर एआईसीटी और पेटेंट ऑफिस के माध्यम से, बौद्धिक संपदा कार्यालय के माध्यम से जिस तरह से इस पूरी सीरीज का आयोजन किया गया है, आपका पार्टिसिपेशन बहुत ही महत्वपूर्ण है। आपको ये चीजें सीखनी होगी। लर्न यूटिलाइजिंग द स्ट्रेंथ, पावर ऑफ योर वर्कफोर्स, these are, and develop your game changing strategies. Why invention is future need? Because we all want कि India should become a विश्व गुरु in this knowledge century. भारत को विश्व गुरु बनना चाहिए, ये नॉलेज की सेंचुरी, 21वीं सदी। जिस तरह से टेक्नोलॉजिकल एडवांसमेंट हो रहे हैं, हमने कभी सोचा भी नहीं था कि एक समय में मोबाइल से फोन कॉल करना 16 रुपए प्रति मिनट था। आज के मोबाइल कनेक्टिविटी की कॉस्ट क्या है? एक समय में इंटरनेट की स्पीड केबी पर चलती थी, आज जीबी पर इंटरनेट कनेक्टिविटी विश्व में सबसे सस्ते और किफायती दर पर उपलब्ध है। एक समय में बात करना, विश्व में कहीं पर भी या भारत में कहीं पर भी बात करना है तो ट्रंक कॉल डायल करना पड़ता था, तो हमें कॉल बुक करवाना पड़ता था और फोन करना पड़ता था। आज विश्व के किसी भी जगह पर हम वीडियो कॉल के माध्यम से बात कर सकते हैं। कोविड से पहले हमने कभी सोचा नहीं था कि वर्चुअली इस तरह से इतने बड़े ऑडियंस को हम मैं एक ऑफिस में बैठा हूँ, आप अपने स्थान पर बैठे हैं और मैं यहाँ से आपको लेक्चर डिलीवर कर रहा हूँ, आप इसे सुन रहे हैं। इस ज्ञान को हम ज्ञान का आदान प्रदान हो रहा है। कोविड से पहले ये क्या संभव था? ये टेक्नोलॉजिकल एडवांसमेंट हो रहा है। हमने हर बदलाव को अपनाया है, हर बदलाव के लिए हमने अपने आप को तैयार किया है। इस बदलाव के लिए, इस गेम चेंजिंग स्ट्रेटेजी के लिए एस्पिरेशन होती है। प्री इकोनॉमिक कंट्री इन नेक्स्ट 5 years, अगर $5 ट्रिलियन इकोनॉमी के लक्ष्य को हासिल करना है तो भारत को नॉलेज इकोनॉमी बनना ही होगा। नॉलेज इकोनॉमी भारत को बनाना है तो हर शिक्षा संस्थान का महत्वपूर्ण रोल है, हर इंस्टीट्यूशनल इनोवेशन काउंसिल का महत्वपूर्ण रोल है। राष्ट्रीय शिक्षा नीति हमें ये मौका दे रही है। राष्ट्रीय शिक्षा नीति में इनोवेशन और शिक्षा को जोड़ने का बहुत अच्छा संयोग हुआ है और इस संयोग के माध्यम से हम हर शिक्षा संस्थान में बौद्धिक संपदा के रचनात्मकता और अभिनव प्रयास को हम बढ़ावा देना चाहते हैं। रिज्यूविनेट द एंटायर रूरल इकोनॉमी ऑल्सो। भारत का 60% से ज्यादा आबादी गांव में रहती है और उनके लिए, उनकी समस्याओं के लिए, उनके लिए टेक्नोलॉजिकल अपग्रेडेशन, आज भारत में फाइबर लेन हर गांव तक पहुंच रहा है। एफटीटीएच भारत सरकार पहुंचाने का प्रयास कर रही है। एफटीटीएच तो पहुंच जाएगा, लेकिन इस टेक्नोलॉजी का प्रयोग समाज के लिए कैसे होना चाहिए, ऐसे समस्याओं के प्रति एक छात्र को, एक शोधार्थियों को, एक प्राध्यापक को संवेदनशील होना होगा। हमें ऐसी टेक्नोलॉजी का नवाचार करना होगा जो डिप्लॉय हो सके, जो समाज के लिए यूटिलाइज हो सके। And we need to increase the R&D participation in the academic activity. We need to have a joining hands between the गवर्नमेंट, कॉर्पोरेट्स एंड कम्युनिटी प्लेयर्स, सबको साथ मिलके कुछ काम करना पड़ेगा। इसलिए आज भी आप देख रहे हैं कि भारत सरकार का बौद्धिक संपदा कार्यालय और AICTE दोनों साथ मिलके बौद्धिक संपदा को कैसे कमर्शियल स्तर पर ले यूज किया जाए, इसके लिए बात कर रहे हैं. वी नीड टू इंक्रीज द टेक्नोलॉजी एडॉप्शन. आज आर्टिफिशियल इंटेलिजेंस, मशीन लर्निंग, फ्यूचरिस्टिक इंजीनियरिंग, ब्लॉकचेन टेक्नोलॉजी, ये सब आ रहे हैं. इस पर कैसे आप बौद्धिक संपदा अगर इन टेक्नोलॉजी प्लेटफॉर्म के आधार पर रहे तो उसे कैसे प्रोटेक्ट कर सकते हैं, एक रिसर्च को ये सारी बातें सीखनी होगी. अगर ये सारी बातें सीख रहे हैं तो आपको शिक्षा का शिक्षा की वैल्यू भी पता चलेगा. एक तरह से हार्मनी हमें लानी है भारतीय व्यवस्था में, और विश्व में फ्यूचर भविष्य की आवश्यकताओं के ऊपर हमें आज नवाचार करना होगा. सस्टेनेबल डेवलपमेंट गोल, 17 सस्टेनेबल डेवलपमेंट गोल यूनाइटेड नेशंस ने दिए हैं. इस 17 सस्टेनेबल डेवलपमेंट गोल को विश्व में हमें अचीव करना है तो कैसे कर पाएंगे. विश्व से हमें पॉवर्टी एलिमिनेट करनी है, माल न्यूट्रिशन एलिमिनेट करना है, विश्व में की क्लाइमेट चेंज समस्याओं को हमें हल करना है. हमें नवाचार की आवश्यकता हो, हमें कॉस्ट इफेक्टिव टेक्नोलॉजी की आवश्यकता होगी. हर टेक्नोलॉजी जो TRL, CRL, SRL पर अगर स्थापित हो सकती है, ऐसी टेक्नोलॉजी के प्रति हमें ज्यादा आने वाले समय में उसका झुकाव होगा विश्व का. अल्टीमेटली एक टैलेंट गेम है, एंड वी नीड टू बिल्ड द इकोनॉमी, वी नीड टू क्रिएट अवर entire education system in such a way that we offer the best opportunity to the society. That's what I have thought, that in about 40-45 minutes of time frame, I would like to share with you how the translation of ideas into invention can happen, and what as a researcher you need to learn, you need to do, you need to develop your skills here. With these words, I would like to pause my submission. Any questions, queries are there, I am happy to answer them. Thank you very much. Namaste.
Thank you, sir. We have a few questions. I'll just put the question here. So the first question is from Mr. Ravi Kiran. How can we identify IP component in invention, and how can we protect it in a startup?
See, IP component, you have carefully gone through my submission that you need to learn analyzing the patents, analyzing the literature, journal references. So which in IP component, it is called a prior art. So prior art search, what is reported till that date in the published literature. And if your IP can be established, if it is different, novel from those references, even if you are combining 2-3 references, then also it should not be obvious for a person skilled in the art. These are a technical terminology which you will gradually learn, but this should not be obvious for any person who is having a skill in understanding. Like a chemist can easily interpret that if somebody has used hydrochloric acid for converting a compound A into compound B, just by merely replacing this hydrochloric acid with hydrobromic acid, HBr or HI, then process is similar, substantially similar. Rate of conversion might be here and there, but chemistry is same. So this is obvious component. And if you are bypassing all this prior art reference, you are meeting the novelty, you are understanding that your component is inventive enough, and if it has the industrial applicability, then you are grossly meeting the patentable criteria, and you should apply for patent. But again, you need to learn and develop this skill. And if you don't have the skill, take the help of the expert who are in this, who have the expertise in this field. And that's why the AICT, TIFAC, NRDC, they have these skill set. PFCs, patent facilitation centers established by Department of Science and Technology. Atal Innovation Mission has the incubation center also. There are quite IP experts in this field. You can also approach the patent agents, patent attorneys who can help you in doing this. They might be charging for their services because patent agent, patent attorneys are professional people who are doing this, they will serve against the services. And there are free resources also available and accessible. Choice is yours. But yes, you need to have a careful submission while you are trying to explain your innovative concept and trying to judge establishing the patentability for your invention. And one thing for sure you need to remember, merely ideas are not patentable subject matter. आइडिया को प्रोटेक्ट नहीं कर सकते. आइडिया को प्रूफ ऑफ कंसेप्ट में आप जो भी टेक्निकल टर्म आइडिएट किए हैं, उन टेक्निकल टर्म को एक्चुअली वो वर्केबल है या नहीं, ये प्रूव करना होगा. और ये सारी बातें आपको एक टेक्नो लीगल स्पेसिफिकेशन आता है, उसमें डिस्क्राइब करनी होगी. तब जाके आपका आवेदन पेटेंट कार्यालय के सामने आएगा और आपको पेटेंट के लिए प्रमाण पत्र हासिल होगा, अगर ये पेटेंटेबल सब्जेक्ट मैटर एज पर इंडियन पेटेंट एक्ट सारे क्राइटेरिया फुलफिल करते हैं. ठीक है.
Thank you, sir. One more question. Why is software is not patentable in India?
नहीं, किसने कहा नहीं है? सी, इसमें थोड़ा ज्ञान हासिल करने की आवश्यकता है. कंप्यूटर रिलेटेड इन्वेंशंस के लिए पेटेंट कार्यालय ने भी एक गाइडलाइन प्रकाशित की हुई है. हमारी वेबसाइट पर भी वो गाइडलाइन उपलब्ध है. आप जरा इस गाइडलाइन को पूर्णतः रूप से उसकी समझ एस्टैब्लिश कीजिए, और उसमें काफी सारी बातें हमने क्लैरिफाई भी की है. ठीक है.
The next question, what are the advantages of patenting over the trade secret?
Trade secret has the better lifestyle. लाइफ साइकिल ट्रेड सीक्रेट की ज्यादा है, लेकिन एक चीज हमें समझनी होगी कि ट्रेड सीक्रेट, जिस दिन ट्रेड सीक्रेट नहीं रहा उस दिन क्या होगा. यहाँ पर एटलीस्ट 20 साल तक आप अपने इन्वेंशन को प्रोटेक्ट कर सकते हैं. बाकी लोग इसका, पेटेंट इज अ नेगेटिव राइट. अगेन, आप खुद शायद प्रयोग करें या न करें, इन्वेंशन आपने डेवलप कर लिया, आप प्रयोग नहीं भी करते हैं, लेकिन दूसरे व्यक्ति आपके इन्वेंशन को कमर्शियली या एनी अदर फाइनेंशियल इंसेंटिव्स के लिए प्रयोग करना चाहते हैं, तो आप उन्हें रोक सकते हैं. तो नेगेटिव राइट है इसलिए. ठीक है. तो आप पूरी समझ इसमें एस्टैब्लिश कीजिए, बहुत फायदे हैं पेटेंट फाइलिंग के. ठीक है.
Yes, sir. And the last question, a lot of innovations are happening, and what kind of innovations are happening to strengthen the India's IP policy?
Sorry, India's IP
Policy.
India's IP policy is the vision document where India wants to be in next few years. And for strengthening the IP foundation, India has given the various objectives into the national IPR policy. National IPR policy was disclosed or made it available, approved by the Union Cabinet on 12th May 2016. And then onwards, we all have seen that the change which is happening in India, government has boosted the IP development, and the awareness about the protection of IP, creation of IP, is day by day, week by week, month by month increasing. We have surpassed the domestic patent filing for the first time in the history of India. We have more domestic patent filing than foreign filing. This is the change which is not just overnight. Dedicated efforts were made towards IP awareness, promotion, offering the protection, optimizing the IP administration, and equally offering the benefit of IP on a commercial front as well. And all together has built up this strong IP regime in India.
Today, my topic, I heard yesterday Dr. Unnat Pandit, and it was an excellent talk. So it's just a continuation of what we did yesterday. And today, the topic given to me is documentation of research. I'm not given the whole title, and patentability assessment. Now, before I go to that, I'll just try to explain what do we mean by research, what do we mean by inventions, what are innovations, can an idea be patented, should it actually be practiced, should it be enabled? These are some of the questions I've been. For me, I've been a scientist, I've been a professor for 25 years, had a lot of students do their PhD with me. And I'll tell you, at that time, I never went and saw even a patent document. We always thought when we are doing research that we should publish. And I remember Dr. Mashalkar's statement saying, publish and perish. So you publish, you will perish. But if you don't publish, you patent it and then publish, then you can get the publication, you can get your patent and this. But many times we don't know. We can write a very good publication. We can do great research. But how do you convert your ideas? How do you convert your research into a publication? How do you convert your research into a patent document, a specification? What are the claims? These are quite mind-boggling for students and researchers. And so let's go and see how we are going to do it at this. It's a very short introduction I'll give. There are many different forms of IPRs: patent, designs, trademark, copyright, plant variety protection, trade secrets, and so on. So we don't have any law for trade secret, but today I'll be only keeping it with patents because these are researchers and we are going to see how we can protect our innovations through IP, and that is mainly through patent. What I always talk of is an IPR life cycle, and I think I must have shown this slide n number of times. That is, you create a research and development. That is a creation stage. And that is what we're going to spend a lot of time today. What are the things that we need to do? How do you document your research? How do you make your logbooks and so on? So research and development is the first key important thing before you can actually get your innovation and protect it. The next comes IP protection, which is what we will be talking about, and then comes commercialization. And when you commercialize, not all patents get commercialized, but they most do get. Whenever you think you can do and plan it in the beginning itself, am I going to commercialize my product? When you commercialize, you get your revenue and you pour it back into the creation. And therefore, creation, protection, marketization are the three forms of the IPR life cycle. People always tell me, should it be a great Nobel Prize winning idea? Can I? But no, even a small innovation can be patented. And I'll explain to this in the next, like the post-it pad. People didn't know that they could even go and a gum or an adhesive, which is a post-it pad. Can you come and actually make an innovation? I don't want to spend too much time on this because Dr. Pandit did deal a lot yesterday. But then it is not necessarily that you have a product and you have only one IP. You can have a product like a phone. It is a patents for how it works. What is your innovation? What is the research in it? Is it a chip? Is it a software to run something and so on? Those are the innovations there, and you get a patent protection for that. But they can also be copyright. It can be for the code. It can be for the way it is there. And that is where you get a copyright protection, where it's an expression of an idea. The design, how is it designed? How does it look? It's an aesthetic appeal, how it looks. It does not have any function to that design, but the look and the feel of it is what you get as a design protection. And finally, we know trademark. That is the logo, the name, and so on. And even small kids can identify a Coca-Cola bottle or an iPhone or an iPad or a Samsung, or you tell them a car going on. They don't know much, but they'll say this is a Maruti Suzuki, this is a Ford. And I'm always amazed at how they can make this out. A lot of the thing is the logo. So whenever you think of innovations, yes, you think of patents, you think of the research, but also think of copyright, designs, trademark, because all put together, you'll get a much higher value than for just one of those IP protection. But today, since we're talking about research and development, we're mainly going to talk about patents. The term of the patent is 20 years from the date of the filing, or 20 years from the international date of the filing. Don't worry about other things. So remember, you get a monopoly for 20 years. But in IP, it can be a negative right. Some of it is a positive right. A trademark is a positive right. A patent can be a negative right. And I'll explain to that as I go along. Now, before we as researchers understand what is it that we are protecting an invention. We are protecting an innovation. And to understand what those inventions are, it has to be new product or a process. It has to involve an inventive step, and it has to be capable of industrial application. So these are the three criteria: novelty, inventive step, and utility that we call. Every time you think of an invention, it must pass these three criteria. And that must be there in your head. I'm doing this because when we do the patentability assessment, we look of it at novelty and inventive step. What is an inventive step? Because novelty, you know whether it's new, it is not new. I'll explain to that as I go along. But what is an inventive step? It means a feature of an invention that involves a technical advancement as compared to existing knowledge. Or it should have an economic significance, or both. And it should also make the invention not obvious to a person skilled in the art. So inventive step does take a long time. And even for a lot of people who've been in the patent field, we are sometimes looking at what this is the inventive step. What are the different types of inventive steps? So when you're writing your patent application, many times the patent agent or the patent attorney will say, okay, tell me what is it that you have done which is a technical advancement, which is an improvement. And it should not have been obvious to a person skilled in the art. Just by changing NaCl to KCl will not be an invention. So small changes will not be an invention, but small changes can also be an invention if you can show the technical advancement. Finally, capable of industrial application means that the invention is capable of being made or used in an industry. These are your three criteria that you must always know and keep repeating it till you're clear that what is an innovation. When we write our papers, we write this is experiments we did. But when we write a patent application, we should know whether it's a product, whether it is a process, whether it is a use, whether it's a method of treatment. What is my invention has to be, and this is the time we spend a lot of time as patent attorneys talking to our researchers. What is your invention? What have you claimed? Can we broaden the scope? Can you do different experiments? And that is where we are doing. So how to make your ideas and innovations work for you? And so this can be an exclusive right over the creation of one's intellect. You do get a monopoly. It can be a negative right. It can be a positive right. As I told you, in patents, is a negative right. You can stop others from using it, but not necessarily that you can use it, because there's something called freedom to operate. So before you use it, you need to check a freedom to operate to see whether you can use it. You can stop all others from using it, but that doesn't mean that you can use it. So that is why we call that patent as a negative right. And so also it can be bought, sold, licensed. So you've got an invention. There are people who are serial entrepreneurs, serial innovators, serial inventors, but they need not come to commercialization, and they will license their innovations to others. And so it can be bought, it can be sold, it can be inherited, and so on. But the patent that you file, it is valid only in the jurisdiction in which it is granted. There's nothing like a worldwide patent. So you have to go jurisdiction by jurisdiction, that is country by country, if you want to get protection for it. Intellectual property rights are the first step to commercialize your innovations by inventors. I'll just give some examples. Can the wheel be an innovation? Is it an invention? You'll say, no, it was known thousands of years before. And nobody can get a claim for a wheel as such. But an application of a wheel to something can be done. I'll just give an example. Earlier on, we had suitcases. It did not have wheels. And so we had to have coolies, we had to have people to carry the luggage, to carry the suitcases when you went by train or by other means. But then somebody got an idea. Wheels were very well known. Suitcases were very well known. And they put the wheel to the suitcase. And today you ask anybody, they'll say, oh, did you have suitcases without wheels? But that's an invention. Suitcases were known. Wheels were known. But the idea of putting a wheel to a suitcase was not known. And that is your invention. So you have to be very clear. People will say, no, both are known. What is so great about it? But nobody before me had the idea of putting a wheel on a suitcase so that I can just pull it along and I don't have to carry it. So there are many such applications of a wheel to an item, to an object, and it's a way you think. I'm just trying to give some very simple ideas that people should not think, oh, no, I can't get an invention. So when you write a wheel, you'll say a hub to receive an axle, a rim, a plurality of spokes connecting the hub with the rim. But where is it used for? It can be used, as I said, in a suitcase. It can also be used in vehicles, a road roller. So wheels have many applications, and each wheel is different. The way you think of it, it can be different. You can also model it differently and so on. So here the wheels have a purpose. The wheels, what is the purpose? What is the wheel doing? You don't claim only for the wheel, you claim the wheel with the vehicle. Or you know that a wheel is used in pottery, so how do you use it? So here are the applications of wheels to real life innovations. And so I just want to tell you that people always think, oh, it has to be some very earth shaking experiments that we have to do before we get an innovation. No, it's the way you want to put your innovations that will come to practice. I also give a simple example of chairs. As you see, each of these, we have 8 different types of chairs, right? And people will say, so what? There are so many chairs, already a chair is, but each one is a different chair. And therefore, each one is novel, each one is new, each one is different from the other. And that's how you assess novelty. And the novelty lies in a specific part of that chair. Everybody knows the first one, number one, is a normal chair. It has a seat, it has a backrest, and it will have 4 legs. Every chair might have that. But let's look at the rocking chair. The rocking chair also has a seat. It also has a backrest. It also has 4 legs. But where is the innovation? The innovation is in the rocking part of it. That first chair I cannot rock. So like my grandparents want to use or grandpa wants to use, and they would like to have a rocking chair. And that is where the rocking chair. I'm not going to give explanation. If you look at number 4, that is useful for folding. I don't have space in my house. I'd like to fold my chair and keep it. Or let's look at number 7. I gave the example of wheels in a suitcase. This is a wheels for a chair, so that I can easily move it from one end to the other end, and it's easy to move it. And therefore, the wheel is known, the chair is known. But one great person had the idea of putting a wheel for a chair where you can then use it. So you have to remember how you're going to be your innovations. Think about it, brainstorm it, and then you can come with ideas and innovations. It's not just research. So when you come, you have to think, what are the types of claims that I can have? Can I have a product claim? Can I have a process claim? Can I have a use or an application claim? Can it be a method of treatment claim? Can it be a composition claim or a means to function claim? So you have to think how to do, and you can have multiple claims, independent claims or dependent claims for covering. So if you have a product, the process to make the product can also be there. Of course, India may not allow use claims, may not allow method of treatment claims, but today we are living in a global world. Today, you don't think of innovations only for India. When you think of innovations, you think of innovations for the whole globe or for certain regions of the globe. And therefore, you need to be careful. You need to think. And even if it's a known compound, but it's a new use of a known compound or a new application for that, you can get a patent in other countries. So I think always don't think of it only as a product and a process. Think of the applications of that, the method of treatments, compositions, and means to function types of claims. This is very important for us. So I just want to again give a little like a summary. It has to be a new idea which nobody has done before, but it's an application. It will result in doing an invention for the first time. Like I said, wheels on a suitcase, wheels on a chair are all first innovations. It did, both existed, but only somebody can go and put it. You need to also understand where your technology lies and what are you doing with that technology. Is it a touch screen to activate a GUI? Is it a chair on the wheels? So you need to understand that you may be using established technology, but you're coming up with a new product, or you're coming up with a new technique to do the same product. That is, I can have different methods to make the same chemical product. So that is also an invention. And you also need to see how to achieve the goal. It's a way, it's finding a way of doing something where others have not done. And if others did not do it and you were the first person to do it, this becomes your inventive idea, like orientation of a display or even a post-it pad. That was an adhesive which didn't work very well. And then somebody said, oh, I can do this very well, and came up with these adhesives for post-it. And that brought about a whole industry by itself. It's also important that the person who files first gets the innovation. So we have the first to file principle in all countries of the world. It never used to be in the US, but it is there. Again, invention is novel, inventive, and has to be useful. First to file, so go and put your application, but you need to know when to file the application. You cannot do it when it's in the idea stage. When it is nearly ready and within a year you can get everything done, that's the time you go and file. So it's an idea and also putting the idea to practice. And that is what we call reduction to practice, what we call enablement. It's just not disclosing your invention, but have I enabled it? Can I brought it to practice? Have I reduced it to practice is also important. Same again, your invention can be only in the jurisdictions that you filed. There's nothing like a worldwide patent. And also remember, simple innovations can also be patentable. A lot of people ask, and yesterday somebody asked again, are softwares patentable? Software per se are not patented, but software implemented innovations can be patentable subject matter. I'd now like to go, I talked about innovations. I'd like to go earlier. What do you do? How do you get innovations? By doing R&D in the lab. And therefore, how do you create? Now, when you create, you're doing experiments. But today's talk that I want to spend time on is how do you document all the things? It's very important. And we Indians are not very good in documentation. And therefore, I'd like all of you all to spend few minutes to see documentation is one of the most important things when you want to patent your invention. Even if it's an idea, document it, date it, sign it. The most important thing for a researcher is his research books. And that is considered as non-consumable. So if you go into big labs and laboratories, and you will see they'll give you a book, notebook, but those cannot be thrown out. Each of the pages will be numbered 1 to 100, 1 to 150. You cannot tear out any page. You cannot scribble on it. And these are called as logbooks. And these are non-consumables. You may leave the lab after your research, after your PhD, but the book stays on. And I tell you, as a researcher, we need to be very clear and we need to document everything that we do. I always feel that we as Indians, we have a lot of oral tradition. That is, we like to talk from generation to generation, but we are not good in documentation. For a patent, documentation is very important. I always say that the Chinese were good in documentation. Japanese are superb in documentation. The Western people are also good in documentation. So if you have to learn about the Ashoka period, you need to go and look at a Chinese writer who talked about the Ashoka period. I mean, this is just to give an example. And I keep stressing because I was a researcher. I was a scientist for 25 years. And only when I went abroad, when my postdoc, I realized the value of keeping your research books. Because that's the first thing that we were taught is what is a research book? How do you write on it? How do you sign it? So every day you do your work, every experiment is documented, signed, dated, and countersigned by either person in your lab or your senior person. This is necessary for all researchers. And the book is a non-consumable and it belongs to the institute, it belongs to the company, it belongs to the employer, and it does not belong to the researcher. And that is something that we need to be very clear about. Every detail of the experiments performed, the materials used, what was the experimental data that you have, everything will have to be. If you come out with a HPLC or a PCR data, you take a printout, it has to be stuck. You need to date it, you need to sign it, and it has to be countersigned as well. You need to keep a record of all your working examples, your non-working examples, the best mode of working the innovation. Earlier on, I've seen that if you don't have the best mode, your patents can be revoked. In India, we still have the best mode. Many countries have taken it off. So best mode may not be known at that time, but if you know the best mode of working the invention, it is important that you also note it down. You may not know at that time, but later on it will come to help you move. And now record who did the experiments for inventorship. Many times the professors will come and give ideas. It's important that that is also written down, because many times even the senior professors can be asked, what is your contribution to the invention? It may be the idea, but did we write it down? Did we put it properly? And so on. So all the discussions, meetings, everything to be recorded. You need to record the drawings of your prototypes, models, CAD design, whatever else you have, anything and everything. Your notebook is very important and it has to be. You can keep in the form of a digital way, but most people prefer to have it in the form of a hard notebook. Even if you have it in the digital, it can be e-signed. Today, everything is digital, so you can have digital way of recording it, but put the date and keep it, because the date of the invention, when you brought it to practice, when you enabled it, is also very important. Keep all the meeting notes, and this I said is a non-consumable and it belongs to the employer. All the above is confidential. It cannot go out of the lab, because this, if your book goes out to somebody else, your whole invention is gone. It cannot be taken out of the lab, and it is the property of the lab or the employer, and it has to remain confidential. There are sometimes we look at references, we write it in a blotting paper. I've seen students, where is your experiment result? They'll show me one scrap paper and say, ma'am, this is the result. Or haath mein likhte hain hum kabhi. Yeah, ma'am, this is the result. No. Everything has to be noted. You need to keep a log of all the important references that you use. And these are important because sometimes we need to disclose it, especially to USPTO and others. So this is a way of not only recording all your experiments, but also recording all the important publications. What did you read about it? Note it down and just write 1 or 2 lines about that publication. It will help you at a later time. When you draft the applications, we say, what is the closest prior art? What was your references? And this will come in useful. I would like to, next thing that is important is agreements. Why do I say agreements is so important? Reason is there can be a non-disclosure agreement that you need, because you may be disclosing your innovation to a third party, and before you disclose your innovation to others, you get a non-disclosure agreement. And today we have that. When you want to get funding with the Department of Biotechnology or Department of Science and Technology or MIT, there is a non-disclosure agreement, because you're disclosing your innovation. even before it is done. It could be an idea. And so those non-disclosure agreements are very important, because if somebody says, I knew it, they are bound by the non-disclosure agreement. Those are contractual agreements. It is used when you disclose your information outside the organization, and it is also necessary to avoid loss of novelty or lack of novelty or allegations that it was already disclosed in the public. These NDAs, non-disclosure agreements with a third party, with another organization, is very important. Employer-employee agreements are also important. So many people think, no, he's a student, he's very good, he's an employee, very good, he's a researcher, he's a student, they're all good. But they will come, work, and leave. And therefore, you need to have non-disclosure agreements with the researchers, with the students, whoever is part of the lab, right from the top to the bottom, because all these belong to the company, belong to the institute, belong to the university. And so these non-disclosure agreements, right from the professor to the students, are required. It's also used to establish the ownership rights over IP created during the employment in general or research time that in general. Deed of assignments. So inventions generally, the applicant will generally be the company or the institute or the university, the employer. And therefore, the inventors are the ones who are inventing it, and they need to assign their rights. So when they're doing the invention, it's important to get this deed of assignments, either at the time of the filing, even before filing, and it's better to have it specific for each patent application. You can have that in your employer-employee agreements. I didn't talk about it because it's more for students and researchers. But when you join a company, there's an employer-employee agreement which says that all your inventions will be assigned to your employer. Those, I didn't talk about it because this was more for students and faculty's members. But that's also some of the agreements that we do. You also need to check for contractual obligations. When you've taken a material, you've taken a microbe from somebody, you've used something, all those agreements should also be recorded and kept, because tomorrow you can run into problems. I know people, when you sign an agreement, you'll say, I'll use this polymer, or I'll use this chemical, or I'll use this microbe, or even a PCR, I use a Taq polymerase. You are bound by that agreement. Or you take a strain from somewhere, you are bound by that agreement. You may not have read the agreement, but they'll say it's good for research, but you cannot do it for commercialization. So every agreement that you sign, even when you purchase a chemical, many times you are bound by an agreement. So please look at those contractual obligations when you are getting material from outside, or it is a joint research, or you're getting material from a company. You have to be careful to understand what are your obligations and keep that in mind. So these are two important points I thought, which is needed for documentation. Next comes commercialization. And so unless you have all this, you've got your patent, you've drafted your patent, you've got it, and you do the commercializing. Commercialization is important because it will give you the maximum output or returns for the IP. And it helps innovators, inventors, or the companies get the maximum value of their inventions, ideas, brands, creations. So today you will see that if Elon Musk could buy Twitter for 44 billion, I'm thinking in my mind, what is this 44 billion that he's got? What is the value? The value is for that platform. So there can be some platform technologies, there could be improvement technologies, and therefore the value is what people feel the value will be in the market, whether it is by revenue, whether it is by advertisement, whether it is by marketing. And today Elon Musk could use his Twitter for doing all his marketing and so on. So remember, the value of the company is a notional value, is a value for the brand. It is value for the platform technology. It's a value. And why that value is there? Because I can see use in the future. And that's what gives you the brand value. The brand value, and if it is not protected, it will be very difficult because a lot of people can copy it. And so even words like Twitter can can be protected by trademark. So don't think only patent, but also think of words or logos that you want to protect it, because everything put together will give you a lot of value. And you need to have a license agreements, it's cross-licensing agreements. How are you doing the funding of research? How do you fund institution? All these will happen when you have the commercialization. I've talked about it, I don't want. Ankush, how much time do I have, or should I stop with this? Another few minutes, can I go ahead, Ankush?
Yes, please go ahead.
Okay, just stop me and when you want, and I will be there. Next is the patentability assessment. As I told you that what is my invention? I told you there's a 3 criteria: novelty, inventor step, and utility, that is capable of industrial application. And so these are important. Usually utility is taken for granted because you won't do an invention unless and until it is useful for you. And therefore, most important for the patentability is your novelty assessment. Is it novel? I showed you the chairs, right? Each chair is novel because it has a feature which is different from the others. And we also do inventor step, but basically we do novelty assessment first to see whether your subject matter is novel. If not, we can tweak it, we can change it, we can modify it, we can improve it to come with better innovations or improvement innovations. There are very few innovations which are platform technology. And if you do come up with a platform technology, you can get a large scope of your invention. But if it's a specific invention or an improvement invention, you'll get it only for that. So first is you need to understand your invention. And that is why I did talk about it in the beginning. Otherwise, you'll say, what is novelty or prior art search? We all, when we do research, we do review of literature. But how many of us do review of the patent literature? Because the review of the patent literature will tell you who are the people filing patents, who are your competitors, what applications have been filed, and so on. So let me give you this example of COVID testing. People say RT-PCR, people will say ELISA testing, people will say so many other things that you can do. And therefore, you need to understand what is your antibody, what is your antigen, how did you do it, what chemicals did you use, what was the probe you used, was it RT-PCR, was it just PCR, what is it? Is all these are forms part of your features of your invention. Now, it should be actually prior art should be conducted before filing of the patent application, and it has to be side by side as you are doing your innovations. You will see whether people have filed such patents or even published any review, any papers in that area. It is required to determine the novelty of the invention before filing. Otherwise, I file without a novelty assessment, and tomorrow the controllers in the patent office, like Dr. Dinesh Patel and others, will come and say, no. There's no novelty. All features are there in this one publication and your novelty is lost. So for a novelty to be lost, all features of the invention should be there in one prior art. And that is called as novelty assessment. And generally we don't allow mosaicing, but one prior art which teaches all features of your invention is considered as novelty destroying document. It can be a patent document, it can be a non-patent document, you need to search both. And when you have your novelty assessment done and your prior art search, it helps in writing a better patent application. And later on, it will avoid costs of either giving up your patent application or costs for filing a patent application for the product or the process or the use or the method. All those can be understood when we do the novelty assessment. There's also a little, novelty assessment is the day that I file the application. Any publication, even one day before, will destroy. Sometimes publication will happen later. That will not be a novelty destroying document. And that as and when you do, you will understand that. So when I do the patentability assessment, I need to first make a list of all the features of the invention. You need to formulate the keywords and you formulate the search strategy. How am I going to go about it? What are the databases I'm going to do? Who are all the key competitors? Who are the scientists working in this area? for the important innovators or researchers in this area, these are search strategies. And it takes some time to go and do your search strategy. You can do a preliminary search, but you need to keep refining your search strategy. You can include synonyms for various terms, go into Wikipedia, go into other things, look for similar terms, and include synonyms as well. You need to refine your search strategy as and when you get. If you get too many hits, that means you've taken a very broad scope. If you've got no hit, that means there was something really wrong in it. And therefore, you need to define and refine your search strategy, your key strings that we call, and get to the right number of hits. And then you record all the relevant results. You may have many, but you'll go and read each one and say, are these relevant or not? And after you've got these results, you will differentiate your invention from the relevant results and say, these are the features of my invention, which is different. For example, a wheel in a chair, on a chair. That wheel is the one which is differentiating that, correct? So you don't claim for the wheel, you claim for the chair with a wheel. And that's how we make all the differentiation. Here, just to show you, each of these are novel. And for each of it, you'll say, this is the different feature that is there. A rocking chair, or a wheel on a chair, or a carved chair. So you need, or a folding chair. These are all the different features that you will do. There are several patent databases which are free, and you can use it for novelty assessment. You can also use Google search for the others. So first and very easy to do is Google Patents. You also have WIPO Patent Scope. They're very good searches there. You can use the WIPO search. These are free. SpaceNet by EPO is very good. It's called Worldwide SpaceNet. And then you have India, which is InPass, and it's improving day by day, and we use it a lot if you want to use the India work. And the other patent offices are USPTO, JPO, China, and so on. You also have something called as a global dossier in the SpaceNet, which gives you for at least 5 different countries. So I would use all these, like the Google patent, the WIPO patent scope, SpaceNet by EPO, InPass, and also USPTO. You need to be a little more good researcher, good searcher to use the other ones like USPTO, JPO, and China. So these are useful databases. You can use the keywords and you can do. If you want to go for Google patent, you enter, you can do this. I don't have to tell. Here I just put in a wheel and a chair and you'll get all the hits. You can go and hit on it. You'll get a lot of information, and that's how you go and refine your search if you want. So you want a chair with an armrest with wheels, and that's how you will get it. With this, Ankush, I can stop. And if anybody has any questions, I'll be happy to take them. But if you feel I can go on further, I'll be happy to take it on.
And we don't have any specific question from the audience right now. You can go ahead. You can explain the common FAQ you also face among your clients about patents like that.
Yeah. Tell me again what you want me to do. I'm continuing it.
Yes, you can continue, ma'am. Also, you can explain common FAQs you faced from your clients on the patents itself.
Yeah, sure. So as I'm talking, I think I'm also giving you those FAQs, what the questions are and all that. So when I said to do novelty assessment, we also do something called a patent and research landscape. Why do we do this? We do this because we would like to know, when you do your research, you do something called as review of literature. The first few months, you just go and look at all the literature that is there, understand what people are doing. So similarly, you can do a patent landscape and a scientific landscape as well, and you can merge it together and see what it is. So when you do a scientific landscape, you go and look at the scientific papers, conference papers, what are the unsolved problems? Because remember, a patent is a solution to a problem. So you need to understand what is the problem and what is my solution. If that is clear, it's easy to write your patent. So problem solution approach is very important for us to understand where your invention lies. And therefore, there could be unsolved problems in the field, And that we do when researchers start working with companies, with institutes, where they say, these are the issues that we are having, these are the problems that we are having. And then you go and try to identify a solution to the problem. So unsolved problems, you can go and identify cross citations. Who are your competitors in the research in your field? You also need to be aware what others are doing in your field of research, and identify collaborations, institutions working in your area of interest, and so on. So this patent landscape or scientific landscape tells you who are all the people working in this area, what is the type of research they're doing, and how can we learn from them. So that first was a scientific landscape. But most scientists would only do a scientific landscape, but we tell people to go and do a patent landscape. What do I mean by a patent landscape? Just like we have scientific literature, we also have patent literature, and you can search either used on a free database, as I showed you before. You can also use paid databases because they collate a lot of information. You can do a lot of things with these paid databases, which may not be possible with the free database. The free database is good for doing the searches to understand where your things are. But if you want to do a more detailed one, we go and use the paid database. The patentability analysis using previous patent and non-patent literature, you need to do that. And you need to also know what is the up-to-date information on technologies, problems left unsolved, who are your competitors, who are the licenses, who are the partners. This will help you in making an informed decision on how you should go ahead with your project. And so all these large companies spend a lot of time before taking up a project to do the patent landscape, the scientific landscape. And if it's a commercial one, a lot of it is important. It will be the patent landscape that they will look at. And it also helps us in identifying potential partners, research experts for collaboration, and so on. It also identifies the licensing deals, and it will identify investors, who is investing in which company, and so on. Because today it is a startup world. A lot of people want to be a startup and create. The value for a startup is their innovation. It is their patents that is the value for their company. And they will get you a detailed insight into the technology. The patent landscape can help you to do that. It tells you what was the past technology, what is the current technology, how is the technology monitored, what is the future of this technology, what will be tomorrow's product. A patent landscape gives you a lot of information which may not be possible in scientific literature. It will also tell you what are the important patents, who's your competitor, who got the first fundamental or platform technology patent, who got the first few patents in your area, who is collaborating with whom, and who are the leaders in certain technologies. All these you can get from the patent landscape. And therefore, we've seen people, this one, they keep a tab on what they are doing as far as the patent is concerned. Now, inventions based on researchers, not necessarily based on the requirements. What do I mean by that? It's very important for us to understand, where is your innovation? Is it a platform technology, like a location-based services platform? Or is it a CRISPR gene editing tool, CRISPR-Cas genome editing tool? If it is a platform technology, like we have the siRNA technology, there are several which are platform technologies. Once you have a platform technologies, then you can go way ahead and get many, many innovations which will all fall within the thing. So you need to understand where your inventions are. Or is it an improvement on the existing technology? Is it an application? Or is it a use of a new use of a known invention is what you should think about? Is it a method of treatment? So you need to go through and understand where your innovation is. What do I sell? If I have to license, what am I licensing? A product, a process, an application, or a use? It can be a concept, like batteries, coming up with new batteries, okay? Or patenting a receptor, or something receptor where you can get multiple antibodies. So these are concepts as well, and you should know where your invention lies so that you can get those. You can write your claims in a broad way. How do you survive? You have to survive because you need to know how to survive in this technology. So it's very important for us to obtain funding if you want to continue your research. And therefore, you need to propagate and teach innovators on how to conceptualize, write good research projects, and also how to write good research business plans. Because nobody is going to invest in your company if you do not have a good business plan. You have to identify the funding sources, identify professionals to help them get you funds and commercialize your innovations, create prototypes, but be careful with disclosure, another aspect of protection. If you've already disclosed your innovation, you will not get your patent for that. And so this is the gene editing thing where you can disrupt the gene, you can delete the gene, or you can add the gene. And this is the famous CRISPR-Cas technology for which Jennifer Doudna and Emmanuel Charpentier got the Nobel Prize. And there was also the Broad Institute, MIT, which were also working on parallel technologies. So they were doing it for prokaryotes, microbes. They were doing for eukaryotes, which are larger species like plants and animals. And you'll see, because there's a platform technology, they founded startups. They were all university people, but they started startups, and the startups started giving license to different companies on a certain aspect of the invention. So your invention is a platform, so you can give it green, those are for agriculture, or for research and tools, that is given in black, or for a specific treatment, cancer, or CAR-T technology, or it is a drug for orphan drugs, or where there are very rare diseases. So all these, depending on the interest of the people, they have gone and licensed those technologies. And this is what we call as the landscape, where you can see people collaborating with one another. This is just to give you that this one technology, CRISPR-Cas, has led to so many licenses, and there are many more. This is a 2018 paper, but just to tell you the wealth of this technology and how you can get licenses. And you don't have to commercialize everything, but you can do this. With this, I will stop. And this is about our firm. And if you have any questions, I'll be happy to answer them. Thank you.
You may be aware that the day before yesterday and yesterday, we started this series with the topic. The first topic was translating the ideas into the invention and what needs to be done by the researchers. Then the yesterday's topic by Dr. Malti, first topic was of course by Professor Dr. Unnat Pandit, our Controller General, and the yesterday's topic was important about the documentation and assessment of patentability by the researchers. And in continuation of that series in a sequence, today is a important aspect to consider while preparing the patent specification. So before going directly to look at what is required or what important aspect one should consider while preparing a patent specification, yesterday also you might have seen a legal language. In legal term, what is a invention first of all, because patents are granted to the invention and not discoveries, and therefore what patent specification is required for an invention, for that matter you must know what is invention first of all. So I will take you just through a couple of sites before directly going to the patent specification aspect. So if you see the invention in terms of the legal language, invention means a new product or a process involving an inventive step and capable of industrial application. So to illustrate it further, we can say the invention, as per that definition into the patent law, that invention must be either a product or process, and that product, first of all, a new product. It should be a new product, and it should have inventive step and industrial applicability. So now three aspects are important when one should talk about an invention. That is novelty, inventive step, and industrial applicability. That is industrial application. So now what is inventive step? So inventive step can be judged in the patent office based upon the technical advancement as compared to the existing knowledge. So existing knowledge means prior art. The patent office used to do the prior art search. So patent office will compare the invention before the patent office filed in a patent application with reference to the existing uh, prior art or knowledge. At the same time, there can be other criteria to judge whether that invention is inventive or not. That is a economic significance. And when these both, that is technical advancement or economic significance, either दोनों में से either technical advancement or economic significance. Additionally, that invention, that is product or process, shall be non-obvious, means it shall not be obvious to a person skilled in the art. Now, when we will be looking after in the coming slides about the person skill in the art and the ordinary skill in the art, these are two different terminologies. But for evaluating whether that particular invention is obvious or non-obvious, the role of person skill in the art is very important. And in other aspect, there is a person of ordinary skill. But for inventive step, you should remember that it should not be obvious to a person skill in the art. So new, inventive with these three aspects, and next criteria is of course industrial applicable applications. So either that product or process can be made in industry or it can be used in industry, so that you can justify the industrial applicability of that particular invention. So this is briefly about the product or process, their novelty, their inventive step, their technical advancement, economic significance, and again a most important aspect, that is non-obviousness to the person skill in the art vis-a-vis existing prior art. So that non-obviousness is of course with reference to the prior art. I cannot simply say being an expert that this is obvious to me. I need to cite a document, a prior art document, and based upon that prior art document, I will be saying that it is obvious to a person skill in the art. And last is the industrial applicability. So this all skeleton finally makes any product or the process as an invention. Therefore, a mere idea which is not a product or process is not an invention. Simply a bucket fitted with a clock and torch, you can see it is not having any technical advancement. Or method of throwing a ball into the cricket match, it may not have a industrial applicability because it is not made in industry or it is not used in industry. So this is just briefly about the invention, because invention is a crux for which the persons used to apply for a patent. So this is all about the invention as per the patent law. So when there is a problem and person thinks about that problem, he may invest, research and do some development, and that idea gets converted into a invention. So that invention can be a product and used by somebody, by stolen by the somebody. So what are the options available when you provided a solution to that problem, but you want a protection for that particular problem, a particular solution, whatever solution you have provided, that must be owned by you. So there are two options: either you keep that as a trade secret, but engineering behind that product can be deduced by others through reverse engineering aspect once that product or the process goes to the market, and thereabout it will not be a no more trade secret, because reverse engineering will get everything about that product, so that may not remain a trade secret, and therefore there will be no motivation for solving the problems into the society or into the scientific fraternity. So what other option is? So get a patent, and that patent provides you an exclusive monopoly right for 20 years with a condition to disclose that invention to the public. So very simple logic here. If somebody goes by this route, trade secret, it will be kept secret with that particular inventor or that particular owner of that particular invention. So you need not to have to disclose that to anybody, and it will remain you for generations after generation. But of course, as I said, there is a chance that somebody can reveal that product or the process by reverse engineering, and then that product or process may not be a trade secret in the future. But in case of patent, when you have been provided a exclusive right for a 20 years, the condition here is you have to disclose everything in a patent specification, so that that patented technology, after the expiry of that particular patent, which is granted for 20 years, will become free to the public. So very logical difference between this trade secret and patent. Trade secret, no disclosure to anybody. It will remain with the owner. But when you are applying for a patent, you are supposed to disclose that particular invention into the patent specification to the government, and that government, after certain time as per the law, will publish that particular invention for the knowledge of the public. And thereafter, that particular technology, that process, that product falls in a public domain. So this is the basic difference between trade secret and patent. So that was about invention. Then what is the difference between patent? So what is the briefly, I'm not going into the details of the whole entire patent procedure. Briefly, when you have an invention, first you are supposed to file a provisional application. It is for Indian applicant, of course. Then after the provisional specification, when you have started with some invention and it requires certain time to complete that technological part, because provisional specification mostly is a manner of it only describe the nature of invention, but manner of manufacturing or manner of producing that product, or manner in which that invention which you are disclosing in a provisional is not there into the provisional. Therefore, after a 12 months period, after filing a provisional, you are supposed to file a complete specification disclosing not only the disclosure of description of that invention which was there in provisional, but now in a complete, you are also supposed to disclose the manner in which the invention which is described in provisional will be performed. So that manner is enabling disclosure and the claims. So within 12 months, you are supposed to file a complete. If you do not file a complete within 12 months, your application gets abandoned under section 9(1) of the Patent Act, but it will not be published. So it will remain with the government custody. So there is again possibility that the person who could not file a complete specification within 12 months because of his own reason can certainly file a fresh application along with a complete, and because of a no publication of that abundant provisional application, the novelty of that particular invention which was disclosed or described into the provisional is still retained, and the inventor gets the benefit of that non-publication. So there can be another way in case of foreign applicants. Suppose you are working in some foreign laboratory, so you can file a first application in a convention country abroad, and within 12 months from that convention application or basic application in that convention country, you can file a complete specification for getting a patent into India. Or rather than filing a convention application in India, the foreign applicant or foreign laboratory persons can file a PCT international applications designating almost more than 150 countries at a time in that single international applications. So there will be single filing date and single priority date. So after getting that PCT international application search, examine and publish at the international level, again you can enter into the national phase with that complete specification after 31 months or within 31 months, not after. So within 31, if you 31 month will be counted from the zero date. That is the first filing. Within 12 months, you will be filing your PCT international application. Thereafter, that will be search and examine before that publication, W0 publication. It is not a world patent. It's an international publication. If somebody comes to you that I have a world patent or international patent with that W0 number, blah, 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 with A1, A2, don't be under impression that that is a world patent. That is simply a international publication of your PCT application at the end of 18 months from the date of priority. So after that 18-month publication, you still get some time to decide whether I shall enter into a particular country which are designated in a single application. So suppose you have selected India also. So you can enter within 31 months into India with that complete specification, and that application will be treated as application before the controller. Thereafter, that application goes for publications after 18 months, because in case of this particular cycle, PCT International, 18 months is already completed. But for this domestic route or the conventional route, after completion of 18 months, that application gets published. In case of a Indian applicant, there is a provision, if you have filed a provisional application or directly complete application, but 18 months will be the statutory time, but there is a optional provision to get a early publication. So you can get your application published early, and there are the benefits of early publications. Normally it happens at the end of 18 months, but if the applicant is interested to get his invention published early, so there is an option for an early publication. After the publication, simply filing and publication is not enough. The applicant needs to file a request for examination, because filing was that time a priority to get a particular date into the patent office to secure a novelty. So you might have filed it, but later on after this publication, you may come to know that my invention is not worth to go for further. So you may withdraw that application by not filing a request for examination, and patent office will not do the examination because there is no request, so there will be no workload on the patent office. But if you make a request for examination, that application will be examined, and there is a issuance of a first examination report based on the patentability criteria provided into the patent law. One more option you must know, that there is a provision for a expedited examination for selected categories. If you are startup, if you are a women inventor and also applicant, if you are a MSME, if you are belonging to certain institutions owned by the government, so certain categories, or if your application is coming through PPH, patent prosecution route, you have an option to file a expedited examination, and within a month from that particular request for expedited examination, examination reports get issued, because that is a separate queue. This is a normal request for examination. It has a certain time, it will take certain time because it will be taken in a queue. But in case of this expedited examination for selected categories notified into the patent rule, it will be immediately taken for examination, and after that reply by the applicant, it will be granted almost in a 1 year from the date of filing. In this expedited route, one can get a patent granted. So once you receive the examination report after normal request for examination or expedited, you need to file a reply to the examination report. And if you do not file a reply for examination report within this 6 months, or that period can be requested by paying the fee by 3 months, so 6 plus 3, so that application will be treated as abandoned by the applicant. So always keep in mind that you have to make a reply to the examination report, and if you do not make, so that application will be treated as abandoned and no patent will be granted. So always, if you are interested to get a patent, you need to file a reply for examination within a time to get a patent. And after that reply for examination, that application can be disposed. It will be either granted or rejected. Simply, there is one more step. If the reply of examination report is very persuasive, the patent will be directly granted. If that response still is not persuasive, requires certain more observations or more amendment before disposal, that is rejection or grant, there can be hearing also. So that I have not covered because it's a brief process. But if there are some outstanding issues between this reply for examination and disposal, that outstanding issues here will be settled by way of offering a hearing. And nowadays the patent office is conducting all the hearings through video conferencing. So this is briefly about a invention, then how that inventions can be secured either by trade secret or the patent, and if it is a patent, what is the procedure briefly in the patent office. So now let us go to our original topic, that is important aspect of patent specification. So there can be two kind of patent specification, as we have seen into the procedural part, the provisional specification and a complete specification. So as I said in the beginning, that provisional specification is merely a description of the invention. Still you are working, how it will be performed, that is manner of working on that invention is under process. So you can skip the claims into the provisional. People used to file, but it is not mandatory that there shall be a claim into the provisional specification. So claims are not mandatory. Why claims I am stressing here, we will see in the next slide, because claims are very important aspect. If the patent is granted in future, claims is nothing but a patent. So this claims is a very important part into the patent specification. So sometime it may happen that when a idea comes into your mind and you have some description of inventions, you may file 2-3 provisional applications. But while actually working in a lab, practically working on that particular inventions, you may come up with a one technology based upon those 3-4 provisional applications you have filed. So there is a provision to make your cognate application. So you can combinedly file a single provisional, some complete after those couple of provisional applications. So you can cognate your 3 or number of provisional into a single complete specification, and only one application will proceed further in the form of complete application. Sometime it may happen that you have directly file a complete because you were having a manner of working on that invention, but later on you came to know that no, that particular complete is not worth, or it has some lacuna or some problem as far as the manner of working on that an invention is concerned. So there is a provision into the law that you can request to convert your that provisional in that complete as a provisional, and you can file within a 12 months from the date of filing of that complete a fresh complete specification. So earlier complete is treated that time as a provisional, and you get a time to file a fresh complete specification, which may be meaningful if you compare it with your earlier one. Also, it may happen that sometime you file a provisional specification, which is not so relevant to the invention, which is there now in a complete specification. And controller might have objected, now let's see your provisional and complete. The provisional is somewhat irrelevant with respect to the invention which is there into the complete. So controller will say, let me, you cannot claim a priority date from the date of provisional application, because what you have disclosed in a provisional is something different, and now what complete with all these working details and enabling disclosure is something else. So there is a provision in a patent law that you can cancel your that provisional, and your application will be post dated from the date of your provision complete specification. So this is about a provisional. Now, when there is a provisional, thereafter, as I said, you are supposed to file a complete specification. So complete specification is a very important document. In fact, a patent application form is merely a bibliographic information and declaration by the applicant. So when you think about a patent, you must have a complete specification or provisional specification. But when complete, so what is the requirement of a complete specification? How to prepare a complete specification? What are the important things you need to disclose into the provisional that are disclosed? If you see this bracket now, I have written in a square bracket S10. In case of provisional, S9 means patent law ka section 9. The section 9 talks about what is the provisional specification, and section 10 talks about the content of the complete specification. So law prescribes that the complete specification shall fully and particularly describe the invention. Here two words are there, full and particular. So every word which is prescribed by the law has a meaning. So we'll see later in later slide what it means by that fully and particularly. At the same time, the complete specification shall disclose the best method of performing the inventions to invention which is known to the applicant. Apart from full and particular disclosure, the best results or the best method of performing or best mode of performing that particular invention is also required to be disclosed by the applicant to enable or to establish his invention in a best way possible way. And finally, that complete specification shall end with a claim defining the scope of invention. So if we say provisional specification, claims are not mandatory, but when it is a complete, your complete specification, that is disclosure part with full and particular description, best method, it shall ultimately end with a very meaningful claim which talks about the scope of the invention for which you are seeking the protection from the government. In very layman language, I can simply say this description part of the provisional specification, that is full particular disclosure or the best method, it is addressed to a someone who will try your invention. That is, it is addressed to a person skilled in the art who may be utilizing your invention during the term by getting license from you, or maybe after expiry of your patent, it will fall into the public domain. So your description is not addressed to the, in a layman language, of course, to the government. It is addressed to a person skilled in the art for transforming that technology into reality. Because patent specification is merely a description. When that technology needs to be worked out into the lab, so that particular description will be used by a person skilled in the art to try your invention, and that is why that is treated as addressed to a person skilled in the art. But this claim component that is defining the scope of protection you are claiming out of that patent is addressed to the government, that is controller. So by way of that claims or defined boundary of your invention, you are seeking through that claim the protection from the government, that I want this monopoly or this legal protection for this particular product or the process which is invention. So therefore the claim is that way addressed to the government, and claim is very important. You have to be very careful while drafting or preparing the claims, because ultimately the claim is nothing but a patent. Description is everything. It includes background, prior art, what were problems into the prior art, and what were objectives of your invention. Then what is the summary of invention, description of invention, detailed description, maybe examples, or in case of engineering aspect, drawing sheets. That is something, a overall embodiments or disclosure part to describe everything. But claim is to seek a protection out of that disclosed invention into the description. So claim is very important, and that is prescribed into the law. Of course, if it is engineering, there will be drawings. Along with this particular specification, you need to have an abstract, so that the publication by the patent office will not publish everything. It will be published along with the abstract. And abstract, what should be the abstract, that is again defined into the law. We'll see what content abstract should have. At the same time, one should also consider this aspect. Section 10 also talks about a deposition details of biological material. In case of the inventions which are using the biological materials in biological sciences, so sometimes that biological material cannot be described into the words to satisfy the requirement of that full and particular description requirement. That time, simply a deposition of that biological material prior to filing a patent application in international depository authorities recognized under Budapest Treaty. So you need to provide that deposition number, that this number and that particular deposit is made in Falana and Falana depository institution. So that deposition details itself sometime can meet the requirement of full and particular disclosure of that particular biological invention, which more often is not possible to describe in terms of a words or in terms of paragraphs. So that deposition is also one of the most important requirement. At the same time, if you are using some biological material, maybe plant, animal, microorganisms, or some living entities, maybe microscopic in nature. So you need to disclose the source and geographical origin of those biological materials which you are using into your invention. So these are the strictly a legal requirement for provisional as well as complete. Now let's go for a claim. As I said that claims define the scope of invention for which you are seeking the protection. So claim is a very crucial part of your patent specification or patent application. In my own interpretation, I can say invention is nothing but a claim, and ultimately those claims become your patent. So that when I said I have a patent for this procedure, so everybody will ask, let us show your patent claim. So that is why invention claims is equal to directly a patent. So claims are very important. They define the scope of invention. As I said, the claims define the scope of invention for which protection is sought. So what way that protection can be defined? That protection can be defined in terms of a technical term. If it is a product, if it is a apparatus, if it is a process. In case of process, you need to have a process steps. In case of product, you need to have its ingredient or its structure. In case of apparatus, you need to define the components in that apparatus. That is why the scope of invention will be defined in terms of a in by way of a technical terms. And one more requirement into the patent law, that invention shall relate to a single invention or to a group of inventions linked to form a single inventive concept. So many times, even in a complete specification, you may disclose number of inventions which are not falling within a single inventive concept. So therefore, there can be a provision of a divisional application that is altogether a different issue. We will not go into that, but try to put a single invention into one patent application, or maybe group of inventions which are falling within the definition of that single inventive concept in a one application. There should not be plural inventions or distinct invention in a one patent application. Then claim shall be clear and succinct. This shall be relating to single invention here means claims of that invention, not a description. Claim shall be related to single invention or group of inventions relating to a single inventive concept, and a very typical requirement that they shall be clear and succinct. Some ambiguous claim or some which are not clearly defined in terms of a technical language or technical sense, what is product and process. You are only talking about I have invented this, I have this, nobody has done is this. So this is not a way to define the invention in technical terms. So therefore, technically, they should be clear and succinct. And very importantly, they shall be fairly based on the matter disclosed into the specification. So as I said, description is one part and claims is another part. But now claims and descriptions are interconnected. You cannot claim something which is not disclosed, not described, not enabled into description, because there is a requirement. Your every claim shall be based on the matter as disclosed into your complete specification. So that is why this claim is very important part, and during the prosecution each claim is very important. Even during infringement or during the revocation or opposition, each and every claim is taken into the consideration. And even after the grant, if the patent is granted, for enforcing your patent right, for getting benefit out of that patent, so claim is very important. So one should not take very casually while preparing a patent specification, and into that a claim shall be very carefully drafted, because that is ultimately your patent. Then now that this earlier language which we covered in this slide is purely a legal requirement. Now in layman language or in popular language, what should be the content of the patent specification? So first content, of course, a title of inventions. It should be very sufficiently indicative of the subject matter of that invention, and should be brief, precise, and free from very fancy or ambiguous expressions. Very clear in terms. You can give a title whether it is a product or the process, what for that product is that. Instead of giving some glossy or fancy word, it should be in very technical sense. Then abstract, as I said, abstract serve as an efficient tool for the purpose of searching for patent office as well as for the outside public. Suppose somebody is interested in some technology, so they will search on a free patent databases or paid databases searches, paid databases for getting a technology for their particular industry. So they will also search for this kind of a invention. And if your abstract is very efficiently drafted, the prospect there is a chance that somebody who has a venture capital can come to the inventor after getting this proper invention to him, and that proper invention can be retrieved by that particular investor only by searching onto the patent databases. And for that matter, your abstract serves either way, also for a patent office to search or to publish your invention, and also to the prospective users of that in technology. So abstract should be very clearly indicating the technical field to which the invention belongs, then technical problem which the invention relates, then solution to that technical problem which you are providing, whether it is a product or process, then principal use, what is the use, what was the technical field, what was the technical problem, now what technical solution, either a product, process or device you have provided, and what is the principal use. There can be a couple of use, but what is the principal use that must be there into the abstract, so that abstract become very meaningful, not only from the patent publication point of view, but also from the commercialization angle. Then the next content into the patent specification that is complete can be a prior art. Now when you have identified a technical field, you know the problem. So how you will come to know about a problem? by way of searching a prior art. This was a prior art and there are problems into the prior art. Now, status of technology in the field of that particular prior art you will be summarizing, and at the same time you will be citing that particular prior art which can be a closest prior art, and you can even point out what are the problems that prior art was solving, but still there is a chance to provide a further solution. So you can identify the objective of invention of your invention over that lacuna into the prior art. So simply listing a prior art is not enough. You are also required to identify what are the problems into that prior art, and as an inventor, what solution now you are intending to provide over that problems into the prior art. So accordingly, after getting a problems into the prior art, you will be deciding the object of your invention. So that object of invention will have a technical problem associated with that existing technology, and the solutions for that bringing out difference between that claim, invention and prior art. So you need to have an object that in view of those differences, those problem in the prior art, what is the object of my invention and what solutions you are providing for those problems. So now that solution will be your invention. So now you are supposed to disclose thereafter summary of that invention. So brief before that detailed description. So now you briefly talk about what is a summary. Summary can be simply sometimes your claim one of that particular or the claims as such. Whatever claims you are intending to include into your patent specification can come as it is into a summary of your invention, so that there will be no objection by the patent office that your claims are not fairly based on the matter disclosed. And in a summary, you will be briefly explaining what all about you are going to claim into your patent specification. So statement that clearly set forth the distinguishing feature of invention which you desire to have a protection. Then for this particular invention, which may be sometime a device or apparatus or equipment or a system, there can be drawings. In case of engineering, certainly there will be drawings. In case of chemistry, there may not be drawings. Chemistry or biotechnology, of course, biotechnology, there is a sequence listing. But in case of engineering inventions, if your invention is relating to that device or instrument kind of thing, certainly there can be a drawings, and that drawings, each drawing can be provided on a separate sheet, and how those drawing can be prepared, there is a prescription into the patent rule. So we'll not go into that detail, but brief description of that drawings is also added into your what is a clear drawing number 1, what is drawing number 2, what is drawing number 3. So you will be listing out in that summary of invention what my 13 or 14 or 15 or 13 drawings are talking about. So you have to give a brief summary of those drawings before disclosing your invention in details. So now detailed description, as I said, that full and particular disclosure of the invention and the best method of performing it is required into the detailed description. Sufficient detail so as to give a complete picture of the invention, which may include examples, drawings, and some prototype model. In case of this engineering, as I said, there can be a different views of your equipment or different angles or different prospective views of that device you are claiming. But in case of the non-engineering like chemistry, pharma, polymer, there may not be a drawings, but there can be the examples, method of testing, using, which is the best method or which is the best product, which is the best composition out of range you are claiming. So there can be a sufficient details by way of examples or by way of drawings, and that sufficient disclosure of invention. So as to now, as we saw the definition of invention, there we saw when I am evaluating in a patent office, whether that particular invention is inventive or it is non-obvious to a person skill in the art, that time as a controller, I will enter into the shoe of a person skill in the art, because person skill in the art may be post-doctor, doctorate or postgraduate in engineering. And if I show the present invention and some couple of prior art document, and if that person is postgraduate in engineering or engineering in science and technology, I will refer that matter to him that see, these are the prior art document I have with me, because in case of novelty you need a single document to anticipate all the features, but in case of inventive step I am permitted as a controller to make a combination of two documents. So whether that combination of two documents is talking about what is claimed in this particular application, So I need to enter in a shoes of a person skilled in the art. So now person skilled in the art here will be postgraduate or doctorate in case of engineering or science subject. So therefore, when we are objecting that this particular invention is not inventive or very obviously person skill in the art, we are utilizing the notion as a person skill in the art. But now if you see here in case of this content of the complete specification, because you may be knowing that patent specification itself shall be very sufficient. No trade secret or know-how can be required after the expiry of a patent, because certainly when my patent gets expired, I will not give any additional information or technology to the person who is using this invention free of cost after the expiry of a term. So logically, patent specification must be fully particularly describing each and every embodiment of the invention, so that without any additional help from the inventor, a person who will be trying that invention in India shall be capable to transform that technology which was disclosed into a patent specification. But whether my patent description is sufficiently enabling, so here in Indian patent law, there is a difference. I am not using here a notion as a person skill in the art. That time I will be using a person of average skill. So that time, suppose it is some mechanical, I will see ITR or some polytechnic student. If he can by reading that patent specification, he should be able to replicate, to transform that invention into the reality. So there is a two difference in Indian. In foreign countries, there is a average skill in the art for inventive step as well as for deciding the sufficiency of disclosure into the patent specification. But our Indian law has typically maintained this, because logic is that technology shall be transformed into the reality in Indian industry. That is why in case of deciding whether that particular description is sufficient or not, the controller will see average skill or average knowledge person in India. So that time that person who will feel that whether that description is sufficient or not, who will judge that? So that level of education may be ITR, may be diploma, or maybe graduate, not post graduation and doctorate. So you need, while filing, you are a researcher, so you need to take care. While establishing your inventive step, you will be thrown with the person skill in that. But when your specification will be examined or evaluated by the patent office, we will apply this criteria whether that description is sufficient to enable that technology by a person with average skill or average knowledge in India. So you should take care at the time of disclosing everything, because most of the time as a controller I have experience that applications come from a research organization or academics. They disclose very scanty information into the patent specification, and they have a 400 500 pages thesis, PhD thesis or MTech thesis with them. And when we say this is not disclosed into your patent specification and therefore this technology is not enabled, your claims are not supported, they say, I have my thesis, sir, it is everything disclosed into that. So that thesis is not a part of the patent specification, remember well. So that is why content of the complete specification shall be very much enough on a date of filing, because scope of amendment is very restrictive. You cannot later on bring some additional information which was there into your thesis. So that is why this aspect one should also take into consideration, because merely grant of patent is not enough. After grant of patent, it can be challenge in opposition, it can be challenge in revocation, it can be challenge in counter revocation at the time of infringement suit. So that time your claims can be invalidated or your patent can be revoked if it is not sufficiently disclosing the things that is fully and particularly along with the best method. And that whole description is a enabling disclosure for a person having a average skill or average knowledge in India. So try to put the most of the embodiments to perform that invention into your patent specification. Do not keep something secret. Otherwise, you will patent after you may get a patent from the patent office. But when you will go for enforcement of your patent right that time, your patent can be invalidated or revoked because of this particular lack of sufficient disclosure into the specification. As we said, If it is relating to biotechnological or biological sciences, you need to deposit first before filing a patent application. When you have created a mutant, you devise some biological material in a laboratory, maybe by genetic engineering, maybe natural mutations, maybe by recombinations. So that particular recombinant variety is not available anywhere. It is only available with you. So that is why you need to deposit that particular biological material into IDA. IDA stand for International Depository Authorities that are notified under the Budapest Treaty, to which India is also a member. So, but the requirement is deposition must be prior to the date of filing in India. So before approaching the patent office, maybe with a provisional or complete, when you have mutant organism, we have created, designed some biological material, microorganism, bacteria, fungi or virus, you need to deposit. And logic behind that, you cannot explain for this full and particular, you cannot satisfy sometime when you have created some biological material, maybe by some X-ray irradiation, you made some UV light, you put UV light and made some mutations into the gene of bacteria. Now you have created once. If you do repeatedly, you may not get the same mutations into the genome of that bacteria. So you as a scientist or the researcher may be knowing that reproducibility in biological system is not guaranteed. So once you got a good mutant, next time you may not get. So that is why whatever good mutant you have and for which you are claiming a patent protection, or you are using that mutant into the process or product, you need to deposit, because that is uniquely available with you and not available anywhere. So you need to deposit, and after deposition you may sometime not able to describe fully, particularly or best way, but or how it is prepared, because recombination or that mutations may not be described into the word. So to meet the requirement sufficiency of description, this Budapest Treaty is there into the picture. So you simply deposit and give that deposition number, date of deposition and that depository institution name. That will meet the requirement of this sufficiency of disclosure. This is all about that, but always that deposition must be prior to the date of filing. Again, sometimes you may not have some deposit material which can be deposited. You are using a natural or genetically engineered by someone else. So you are using some biological material. So you need to disclose the source and geographical of the biological material. And this particular requirement into the Patent Law Act is our obligation under Convention on Biological Diversity, that is called as CBD. And after that CBD, sui generis, we have a Biological Diversity Act, and there is a section 6 under the Biological Diversity Authority, which gives the permission when somebody is using some biological material obtained from India. So right now that's unamended section 6 is there. You can refer this Biological Diversity Act section 6, which mandates that applicant need to submit a prior approval from the NBA before getting a patent. But now very recently in December 2021, Government of India has notified the Biological Diversity Amendment Bill 2021, and that section 6 is now little bit simplified for Indian as well as foreign applicants. So this is just for your academic interest. Those who are interested will certainly look into what is current section 6 and what amendment government has proposed. Now that particular bill is given to the Joint Parliamentary Committee for report, but it is a academic or extra interest for your reference. We will not go into detail of those section 6 of the existing and proposed, but always keep in mind that you have to disclose the source and geographical origin of the biological material used. It is an obligation under the Convention on Biological Diversity. And further to this Convention on Biological Diversity, now India also signed a Nagoya Protocol which talks about access and benefit sharing. So even sometimes if you are using a biological material obtained from foreign country, it may not be from India, but in Nagoya Protocol somewhere you are required to produce to certain authorities in country whether that biological material is obtained authorizingly from that foreign country. This is something under that Nagoya Protocol. So you can also see what is that Nagoya Protocol subsequent to the Convention on Biological Diversity. In case of biotechnology or biology related inventions, reference to the relevant sequence site is, because sometimes you may be claiming a polypeptide, polynucleotide, antibodies, monoclonal antibodies, polyclonal antibodies. So these all antibodies are again by that 80 GC of nucleotide or 20 standard amino acid sequence. So that cannot be explained in terms of this full and particular disclosure. So you will be reproducing that sequence listing, and at the same time, whenever you are describing that invention, so which sequence ID of the 1000 sequence you are reproducing is relevant. So you have to identify a particular sequence ID within the bracket or near to that particular feature of the invention, if it is a process or the product. So sequence IDs of that particular biological protein or polypeptides or antibodies is also important. And as I said, while doing all these things, one need to take care that you are claiming a single invention or a group of inventions constituting a single invention concept. Let's say the example in case of biotechnology, suppose I am claiming a polypeptide. So certainly along with polypeptide, I can claim a polynucleotide which is encoding that polypeptide. Again, I will say what is the use of that polypeptide or polynucleotide. I will say a composition, medicinal composition comprising that polypeptide or polynucleotide. Again, I will be claiming a different compositions of that particular product. At the same time, I can say how that polypeptide or polynucleotide prepared, maybe by genetic recombinations into some host cell, and then I got that new gene. I recombinantly produce first of all a gene, then I put that gene into the host cell, then that host cell produce that particular polypeptide or polynucleotide. Now that polypeptide is interferon, that is monoclonal antibody, that is biologics. So these different sets of independent claims pertaining to that particular polypeptide or polynucleotide will be a group of inventions falling within a single interest. This is a best example to explain how you can have a multiple independent claims in a one patent application, but they are falling within the umbrella of that single invent. You can say protein, polypeptide, gene, host cell, composition, method of preparation, their application, their use, sometimes method of treatment. One more aspect, now when I talked about this biotechnology, if you see the Indian patent law section 21J, what is invention? Section 3 and 4, what are non-patentable inventions? Suppose your invention is really worth to go abroad. Now there is a next lecture by Professor Ganguly. They will talking about how to judge the worthiness of your invention to file abroad. But suppose it is really worth to file abroad, you may be filing a single application, PCT international application, or maybe couple of conventional applications into a conventional countries of your interest where you find that there is a business for your invention. So for that matter, now different country have their own patent laws, and patents are granted as per their domestic patent laws. So if you are an Indian inventor, certain things like a method of treatment or use claim or Swiss claims, they are not allowable in Indian law because they are neither product or process when they are used, and if that method is a method of treatment, that section 3I of the patent law exclude that method of treatment is not allowable. But when you are filing a application in a foreign country, taking the priority of this Indian application, your own application, maybe a conventional or PCT international. So you can claim those method of treatment or use claims or some other inventions which are patentable in there. So while filing, at least your Indian application should also have the description as well as claims relating to those inventions which may not be patentable in India, but you may get a patent abroad. Like in US, you may get a patent for method of treatment as well as in Europe, you get Swiss type claims or a composition restricted with that particular use claim. So while preparing this description and a claim, you should also think globally, because now in a global village concept, your invention sometimes may not be merely useful for India, it may be useful for hundreds of countries across the world, and you may require a patent protection for going to those countries. So while preparing a patent specification, you should also have all embodiments into the description as well as couple of claims to those matters, so that you can say my Indian application whose priority I'm claiming here in US or in Europe or in UK or in China, in Japan, have that particular disclosure as well as claim. And that is why I'm entitled to claim that invention there into that country. So this is also one of the important aspect when one is thinking about going abroad. Now claims, the ultimate part which I said, the claims are very crucial, or we can say the most crucial part of the patent specifications, and claim is nothing but a patent. So in other language, very popular language, you can say the claims is a protective fence around the invention, which is defined by words and by phrases in the claims. And also claim defines the legal protection in technical terms. Now one more, just like when I said, when you are thinking about going abroad, what you should have into your patent specification, that all embodiments which may not be patentable in one country but they may be patentable in other. So you should include everything when you are thinking to go abroad. Similarly, when someone is thinking about a legal protection, so that legal protection can be, now suppose you are a you people mostly used to publish a research papers, research articles. Always the academics or research institute preferring a paper publication. So I am also a PhD student once upon a time, and when we were publishing a paper before joining this patent office, so I know what is the emphasis into the that particular research paper. We are writing some introduction, background, we are giving what materials and method, and under result and discussion, we are disclosing everything, we are discussing everything, and that result and discussion part of your research article or paper runs maybe in a 10 to 20 pages, and whereas the materials and method maybe a couple of paragraphs only, not pages. So what is the difference between that research paper and patent specification? In a very simple or layman language, I can say the claim here in patent specification, which is the most crucial part of your patent application, is their materials and method into your research article. And I know while publishing a research paper, we are not putting much emphasis onto that material and method parts. We are disclosing variety of results out of that material and method which we use for doing the experiments. We are describing all the results, but in a patent specification, that results and discussion part goes into a statement of invention, detailed description of invention, and the examples, best examples to disclose the best mode or best method. So that result and discussion part which was there into the patent research article is a part of the description into the patent specification. That is not a claim. So when you are converting in a lab your research paper into the patent specification, always keep in mind that you need to properly, in very techno-legal sense, you have to write that material and method part in the claims, because that material method is nothing but ultimately the claims. Because of this method or that method, you got that result and you are ultimately seeking a solution. You are providing a solution to the problem in the prior art. But by which method or which materials, that comes into the claim. So always try to convert a research article into the patent specification by putting a great emphasis onto your materials and method part. This is simply may not be in a legal sense, but in layman language, you can simply think about converting your that materials and method with all other embodiments to claim a patent protection. But to my understanding, what you are putting into the research article is not enough to come up with a very meaningful claim, and in terms of techno-legal language, because that patent research paper is not a techno-legal document, it was merely a technical document, scientific document. But now when you come for a patent, that patent specification becomes a techno-legal document, because in a legal terms you are seeking a scope of protection out of that technology which is there into that technical paper. So there is a difference, research article and patent specification. Research article is purely technical, whereas the patent specification is techno-legal. While preparing the claim should not be too broad, otherwise you will encroach upon the subject matters of others, and in future your patent application or your patent may be invalidated.
So I'm sorry to interrupt. So we are Right now, 3 o'clock, sir.
Okay. So just give me 2 minutes only.
Yes.
And now you see there is as I already covered that you should take care while putting a complete specification that everything is disclosed on date of filing, because there is no scope for further amendment. Only amendment by way of disclaimer, correction and explanation are possible. Simply for incorporation of actual facts, and you cannot add anything which was not earlier claim, or you cannot add something which was not disclosed. So scope for amendment in patent specification is very restricted. So you should take care at the time of filing only. Similarly, there is a chance that during the pre-grant and post-grant appositions, if your patent application is not sufficiently and clearly disclosing the inventions, or not disclosing or wrongly mentioning the source and geographical origin, these are the ground for opposition. Similarly, once the opposition period is over, but you may go for enforcement or your patent right. So during that enforcement or revocation or counter revocation, if your patent specification is not disclosing all the aspects which are required, so these are briefly about the grounds on which your patent application or patent can be revoked. So mind well that patent specification shall be very completely, fully, particularly and meaningfully claim everything. Otherwise, even after the grant by the patent office by your submission, but during the enforcing your rights, it can be struck down. Granted patent can be revoked in a position, or patent applications can be refused in a pre-grant. And even after 10 to 20 years during the enforcement of your patent rights in infringement suits, even the alleged infringer can invalidate your patent because of a insufficiency which is disclosed in this ground. So this is all about. Thank you.
Is assessing worthiness of inventions and creating strategies for patenting them outside India. And you've already attended 3 lectures in the last 2 days. This is the 4th lecture in the series. And what we will do is, I will straight away go to the starting point. And that is that as researchers, as students, as faculty, as academicians, and also possibly as entrepreneurs, we may have lots of innovations. Mark the word innovation. The question is, you've already gone through a process of hearing from the 3 very eminent speakers what is the best way to protect an innovation that you have. Question that comes in, how do I make it my intellectual property? It's a creation of my mind, but how do I convert it into my property? And more important, how do I convert that property into an asset? So the question that comes in, should I just go and disclose it to the world? Or should I first protect it and then disclose it to the world? That's the first question. I think this question has been answered already by Professor Unnat Pandit, also by, Malti Lakshmi Kumar, and by, Dr. Dinesh Patil. Question that comes now is, should I get it protected in other countries in addition to protect it in India? And if I do it, then the question is, how do I benefit from this activity? So it's a big question in front of me as a researcher, as a student, as a faculty, as an entrepreneur, that I have this innovation in front of me. Question is, do I only keep it as a protected property in India, or do I protect it across the world? Why do I need to protect it across the world? Is the question that I'm asking myself. So therefore, I need to go to some basics, and those basics have already been done, but I will just repeat it just for the sake of a quick recollection. And you've already understood in the last 3 lectures that the patent is a grant. This grant is given by whom? By sovereign or state. That means this state is not state of Maharashtra, not state of Rajasthan. It is state means India, the country. So it's a sovereign or state, independent country. Given, this right is given to whom? It is given to a person. What sort of right is it? It's an exclusive right. Interestingly, what you must have already heard from the earlier 3 speakers, that this right, exclusive right, is a negative right. What do we mean by negative right? It is to stop others from making, using, selling, offering for sale. What? An invention. So now I've changed the word from innovation to invention, right? So it's an invention. How long do you get the protection? It's for a limited period. The question that comes in, what do? You can stop somebody making, using, selling, offering, or offering for sale your patented invention without your consent. So somebody must take your consent, must take your permission to do all these activities. Then what Dr. Dinesh Patil has already talked to you is that you have to do it in exchange for disclosing it in a patent specification. So Dr. Dinesh Patil explained to you all the good practices of how to write a good patent specification. You have to write it in such a way, and Dr. Patil has already covered that, such that a person skilled in the art can reproduce the invention. So that is where the patent specification comes in. You file this particular patent specification in the Indian Patent Office, for example, and then the process of patenting starts after you have filed it in the Indian Patent Office. Now, important part for us to understand and recognize that all intellectual property, be it patent, be it copyright, be it in design registration, etc., all these things that we are talking about, this is about knowledge ownership. So which means that if you are given a grant, you own that knowledge. If you have been given a patent, granted a patent for your invention, then you own that invention. You are the owner of that invention. You get some rights for it. Do you get that rights forever? No, it's a limited time. And do you get this right? Where do you get this right? It is territorial. Very important for us. Territorial. So when we are talking about territorial, it means your right is restricted to the country in which it has been granted. There are certain exceptions and obligations. I will not touch that at this point in time. Important for us to understand that this particular right which is given to you is territorial in nature. So the question that comes in front of us is one patent application in India. I can always ask myself, is one patent application in India not sufficient to give me protection in all countries? Then the question that comes in, if I have to file patents in various countries around the world, how do I plan for it? What is the process of doing this filing and getting the protection across the world? And what is the cost? Very important for us. We need to check on all these points and ask these questions and find the answers to it. And I'm going to answer these questions as I go along today. Similarly, there's one more important part that we need to recognize and understand. Understand. The grant of a patent is by the state or sovereign. This patent right is valid only in the country, within the political boundaries of that particular country in which it has been granted. So which means if I file a patent in India, then my rights are restricted to India only. My patent right is restricted to India only. I can only stop others from making, using, selling, or vending the invention only in India with a patent that's been granted to me in India. Can I stop somebody in Bangladesh? Can I stop somebody in Nepal? Can I stop somebody in Sri Lanka? Answer is no. Because my rights have not been given by that government. The right was given to me by Government of India, by the Indian Patent Office. And therefore, my right is restricted only within the political boundaries of India. And there is no concept of international patent. And because there is no concept of an international patent, it is incumbent on me that if I am seeking protection in Bangladesh, if I'm seeking protection in Pakistan, if I'm seeking protection in Nepal or Bhutan or any other country like US or wherever, then I will have to file that particular patent in that country, and I have to get the rights in that country as per the patent law in that country. So which means that simply filing a patent in India only, I do not get my rights across the world, because there is nothing called an international patent. Therefore, the question that comes in, that how do I go about doing this? And the first part, the question that we should ask ourselves, why do I need to protect it in other countries? Is it not enough? Or because I'm doing my business in India, or I'm going to, commercialize it in India, then does it make any sense for me to go and file this particular patent in other parts of the world? I need to ask that question. I need to answer that question. And that's precisely what I'm going to do. Now, so therefore, when we go to the next part, before we go into all this, we have to appreciate that there are what are known as international agreements and conventions in which countries come together and they agree among themselves that, okay, we agree as a group of nations, right, under certain conventions or agreements, that we will, go about respecting each other's rights in a certain manner or give the rights in a certain manner. And therefore, there are several agreements related to patents. There are agreements for copyright, there are agreements for design registrations and other forms of intellectual property rights. But since we are talking about patents today, we are talking about, a certain set of conventions or agreements. One of them is where some set of countries come together and create what is known as a convention among themselves. And they agree among themselves, okay, we will agree to do the following things together and we will respect it because we have agreed it together. So those are called convention countries. Now, there is one convention called the Paris Convention. And in this Paris Convention, so many countries came together. Today, there are 179 countries, as I speak today, who are members of the Paris Convention. Right? We will talk about what the Paris Convention does in a minute or two. Then there is this organization, a UN organization called the World Intellectual Property Organization, WIPO, which is located in Geneva, in Switzerland. So they run a program, or they run a system, a convention called Patent Cooperation Treaty. In short, it's called PCT. And this organization, mind you, cannot grant patent, right? Why it can't grant patent? Because it's not a country. It's not a government. It's a governmental agency, intergovernmental agency. So they can create a system, a platform where they can facilitate people to file patents out there. That's what it does. So the PCT system, what is there, does not grant patent, but helps you to file patents across the world. Now, so when you look at something like this, what does it do? And I will go into a fair amount of detail on PCT after a few minutes. Similarly, there is one more convention, and that convention is called the Budapest Treaty. What does the Budapest Treaty do? It says if you're dealing with microorganisms, then we said that people who are skilled in the art should be able to reproduce your invention. So if I'm using a microorganism for my patent, and if somebody wants to repeat that, how will they do it? From where will they get that microorganism? So this particular, called Budapest Treaty says that you must go and deposit that microorganism which you have disclosed in your patent specification, put it in a certain depository, an international depository, so that anyone who wants that microorganism can go to the depository and ask for it to work on that particular microorganism. Similarly, there's what is known as international patent classification under what is known as the Strasbourg Agreement, and one which you have already heard, which is,
So can you hear me?
Yeah.
We are not able to hear you.
You're not able to hear me? Oh God, what happened? What
Yes,
happened?
we can hear you.
You can hear? Fine.
Yeah.
So, okay. So
I can
there is
also
what
hear
is
you,
known
sir.
as the TRIPS Agreement, which is called Trade-Related Intellectual Property Rights, which is governed by the World Trade Organization. And as we speak today, under that particular thing, what the World Trade Organization, what the TRIPS Agreement does, it sets the minimum standards for members of WTO to follow while framing the national laws. India is a member of all these conventions which I've listed here. So under those
Dinesh
conventions
sir,
and
can you hear
agreements.
Prabhuda sir's voice?
Can you hear me?
I can hear. I'm hearing him. I think so. There is some problem at your end. We are able to hear Dr. Ganguly.
Okay, should I continue?
Yes, sir. You continue because
Okay, so I'll
I'm able to
continue.
hear you.
Fair enough. So let me continue. So all this list of agreements or conventions which are there, all these in which India is also a member. Therefore, as a filer of patent in India, I can take advantage of all these conventions to go and file my patents across the world out there. Right? Now comes in, I will go into only two of the agreements out here, what is known as the Paris Convention and the PCT, and ask ourselves a few questions as we go along. And then we will go into the strategy part of it. So when we look at this, when we work it, so the question that comes, as I said, why should I file my patent in other countries? And what are those considerations that I should keep in mind while taking a decision that should I file this particular patent application only in India or should I go in other countries as well? And one of the first questions that comes about is which are those countries where my invention has a market or can be sold? So that's the first question. Because why should I file it in other countries if my product or process which I have developed, if that does not have a market in that country, then why file a patent? Why unnecessarily spend the money? So I need to ask a question. So therefore, when I have an invention, I need to first find out where all in which parts of the world my invention has a market. So it's very significant and important to first establish that so that I then decide whether I'm going to whether I'm going to protect it in that country or not. Next question, which are the countries where the invented product may be manufactured? So which means why? Because that means I will have competitors in those countries who may manufacture my product. So how do I stop them? I want them to take my permission if they want to manufacture. So I must identify those countries in which my product may get manufactured. So I may like to protect it there by filing a patent in that particular country and then stopping others from making, using, selling, or vending my invention without my consent. Very important. So that's a point number two. Let's come to a point number three. Which are those countries where the invented process may be used? I may not have a product patent, but I may have filed a process patent for a process. So I must find out those countries where my process can be used. So I must go and protect it in those countries. So I must do that research for myself. So only doing the scientific research or technical research is not good enough. To work my business strategies on that. Similarly, next question. Not all, I'm sure Dr. Pandit, and also Dinesh Patil and Malti would have talked to you that not all types of inventions can be patented in all countries. Certain types of inventions are not allowed to be patented in certain type of countries, certain countries. Therefore, you need to evaluate, you need to assess, make an assessment. I have invented, I've created a new microorganism. Can I file that patent in that particular country of interest? And will they give me a patent for that? Or are there any restrictions in patentability of that? I need to establish that. Similarly, I may have developed a new method of doing surgery. Now, whether that new method of doing surgery is patentable or not in a certain country, there's no point in my filing a patent if that country does not give a patent for methods of surgery on human body. So I need to find that out. Therefore, I must go and read the patent law or find out from an expert. Well, this is what my invention is. Do you think, even though it has market in some other country, will it get patented there? I need to ask that question. So that is another question that needs to be assessed in the series of parameters that I have to assess. Similarly, the question comes in, that are there companies or organizations or governments where they may be interested in taking permission from me, license, or even purchasing the patent from me? And so that would be another point. I need to assess that here is my invention. What is the depth of my invention? What is my invention? And whether the countries in which I want to go and file a patent, whether it is of any interest or relevance in that particular country. So these are the first set of questions that I need to answer. Here's the second set of questions I need to answer. Let's go to the second set of questions as we go along. That is, we continue on this journey of asking questions for hours. So we have to assess. So which are the countries where the patent can be effectively enforced? That means I file the patent, I get a patent. Somebody copies me there without taking my permission. What can I do? Can I go to the court there? Can I fight a case? Will I win? So the laws of that particular country are going to be very important to find out whether I can effectively enforce my patent. So simply filing patent, okay, fine, you have a patent. So what? So I have to ask these questions. I have to assess the relevance and whether my patent can be enforced in that country or it cannot be. Now, which are the countries where there are matured patent markets? Nowadays, can you believe it? Like we buy and sell fish, like we buy and sell vegetables, like we buy and sell fruits. Today, interestingly, there are patent markets. So there could be certain countries where the patent markets are very mature. Now, if I file my patent in those countries, for a patent application, I get my patent in those countries, then I can enter the patent market. So I don't have to manufacture there. I go to the patent market, maybe I sell my patent. And I get the money that I invested. I get the benefit of my, mental creation, the creation of my mind. Very important. Similarly, there are various countries today, various organizations today, where you can take the patent, go to the bank, go to a financial institution, and say, here is my patent. The value of this patent is so much. Please keep the patent with you. It's like securitization. Securitize. You give the patent to that particular financial institution, hold it, give me so much money on loan. Right? So question comes in, can I use my patent because it's an asset? There's a value to the patent. So if I've done good work, if I've evaluated that particular bit, if I've seen that my patent now is of a certain value, then I can go to a financial institution, I can go to a bank, I can go to such places and say, hold it. जैसे gold, दोनों को हम गिरवी रखते हैं, वैसे patent को भी हम गिरवी रख सकते हैं. We can keep it out there and then take a loan against that. And when I pay the loan back, I say, okay, take the patent back. Very important. When we buy house, we take loan. What do? We mortgage that particular house to the bank or the financial institution. Exactly, you can do that with patent. So we need to look at all those aspects. Then also, very important, I may have strategic collaborators in certain countries, and I have to identify that. And I can find out which are those countries where one can find strategic collaborators. But if I have to get strategic collaborators, I must first protect my invention in those countries and then seek collaborations. So there are a large number of such parameters, So, which are important for us to not only recognize but also to act. So these are some of the parameters that we need to assess. Now, if we do all this, which means that before I file or file my patent in other parts of the world, right? I have to do a lot of homework. It's not just go blindly and go and file, because it costs a lot of money to file. It costs a lot of money to get the patents. Just simply filing does not give you a patent. You know, the moment I file a patent application in the Indian Patent Office, Dr. Dinesh Patil's team goes into it, makes an assessment, does an examination, then tells that, look, these are the reasons why you may not get a patent. Then you have to justify. You have to then go for the examination. You then have to go for a hearing. All these cost money and time. So before investing on all this, you therefore must take a quick call and assess, is it worth really filing this particular thing into? And will I get the money back, whatever I'm investing? And I make a strategy out there so that in the long term, I benefit from that. So these are some of the strategic thinking when you say, I will file the patent abroad or I will not file the patent. Just very quickly now, I will run through some of the international conventions under which you can file this particular patent abroad, and then what are the ways in which you get a patent abroad. And then we will take a few case studies as I go along, okay? So taking this cue from here, let's take the Paris Convention. What is the Paris Convention? India is a member of the Paris Convention. Very simple. Don't go into too much of the law. You have to just simply remember some of the principles that are there. So what does the Paris Convention say? Very simple. That within all these countries, they have agreed that if you have filed your patent for the first time in any one of these member countries, that day on when you file the patent in one of the countries for the first time, right? That's called the priority date. It's the date of birth of the patent, DOB. Now, that's called the priority date, which then the Paris Convention in very simple terms says that if you file that particular patent, let us say on 29th of April 2022 in India, and that was the first filing that you did in India, that's the priority date. Starting from there, within 12 months, you are expected to go and file the patent in other Paris Convention countries. So even after filing the patent application in India, after the priority date, if you have gone and say sold that particular item in India, or you have made a presentation in a conference in India, it has gone to the public. Now, within 12 months, you're allowed to go to any of the Paris Convention countries and file that. And when you file that particular patent within patent application within 12 months of the priority date in India, those countries will respect that priority date. And by respecting the priority date, what do I mean? That even though I went to public after filing the patent application in India, that those Paris Convention countries will take as if I had filed it in those countries on that particular priority date. So they will respect those things. And therefore, what is known, which Dr. Patil and Malti Lakshmi Kumar must have mentioned to you, that this concept of novelty, I don't lose my novelty because my priority date is respected for 12 months. So that within 12 months, I can go to any of the Paris Convention countries and file my patent application. That is what the Paris Convention says, which means that I can do that in all the 179 countries that are members of the Paris Convention. But important part of it is that I must do it within 12 months. So what happens if I can't file that patent application within 12 months in other countries? Then is it that I can't go and file the patent application anywhere else in the world within those afterwards? That question is answered by what is known as the PCT, the Patent Cooperation Treaty. Now, what does the Patent Cooperation Treaty do? It says very simple again. Let's not go too much into the law part of it, but let's understand the principles. What does it say? That if you have filed a patent application for the first time, example, in India, let us say on 29th of April 2022, then what the PCT convention says, of which India is a member, what the PCT convention says, that within 12 months of this priority date, 12 months, like in Paris Convention, then PCT says you don't have to go to the various countries and file your patent application. File one patent application under the Patent Cooperation Treaty within 12 months. And if you do that, then the window when Paris Convention, which was only 12 months from the priority date, opens up to 30 or 31 months, so which means that you are no more restricted to file your patent across the world only in 12 months. You can actually, if you file a PCT application after filing your patent in India, you can actually file your patent application in other parts of the world after 30 or 31 months. So you get more time to think and answer all those questions which we raised before. So you then take your time, sit down after filing the PCT application and think about all those questions that you need to answer. So that is to evaluate the patentability in countries of interest, shortlist the countries and the regions, and then you file a PCT application within 12 months of the priority date. Very important that you need to think about all these. And for all this, mind you, you don't, as researcher, a student, or faculty, you don't have to go into the nitty-gritty details of this. You have to only appreciate after this lecture that you have such options. And we have the professionals who can help you. Not only that, the Indian Patent Office itself has a certain guidance. It has got, certain guidance it can give you, and we can help you to really overcome all these, how to do, what to do, where to do, and what not to do. So the question is that you need to be aware that this is the potential. This is what we need to do, and this is what I need to think about. Very quickly, just to tell you that if I have to file a PCT application, I don't have to go to Geneva. I can file it even in the Indian Patent Office, right? Because the Indian Patent Office is recognized, for PCT as well. So there's a separate department in the Indian Patent Office which does that. Just to cut a long story short, to file a patent application, PCT application, it's roughly about 1.23 lakh rupees for one application, right? Plus, there's a certain amount of things you may need, about 13,008. So roughly, give or take, about 1.5 lakh rupees that will be required to file a PCT application out there. That is the thing. Now, just quickly, what I will say. So, what do you get out of this? I filed the PCT application. So here, 0 priority date. That means application filed in the patent office, which was the priority date. And within 12 months, I filed the PCT application. The moment I file the PCT application within 12 months, you can see I get 30 or 31 months, completely from here to here to file my patent applications in other parts of the world. So, but what do I get by filing a PCT application? How does it help me? And how does it help? Because what happens is within 4 months of applying for the PCT application, they give you, the PCT office gives you, something like an assessment of your patent application. Whether it will be, what is the likelihood that it will get patented? What is the likelihood that there is enough, literature which will probably destroys the novelty of your invention? Or what is the literature that may possibly destroy the inventive step? So it gives you a report. It's like a scorecard. And now you can assess using the scorecard what you want to do. So just to take you further through that. So here, suppose I filed the, a patent application in India, then within 12 months out there, I can file a PCT application. The moment I file that, I get the 30 or 31 months window opening up. I'm not restricted to 12 months only to go and file my patent application in other parts of the world. Now, see the other part, very important part, what the PCT helps you. That, when you go and file, for example, a patent application in China, or you file a patent application in Japan, you file a patent application in Korea, then you to get your patent specification, which Dr. Patil told you have to translate that in their language. Now you can't translate it. There's to be an official translation, and that costs a lot of money. So if you are clear in your assessment that I must file it in Korea, and there are good reasons for me to file it in Korea, then I will get the translation done. But by filing a PCT application, at least my priority is protected. And then I can take those 30 months to get all those translations and everything done. And then assess whether I will pay those fees or I will not pay the fees. It will depend how important my patent is going to be in Korea or Japan or wherever it is. That's the first part. So, when I get the PCT report, I can then do a quick assessment out there. So what does that do? The research, the PCT report tells me what are the technical areas that were searched by them. They do a patent search. And having done a patent search, they tell us, oh, in this particular application, you may have more than one invention. Therefore, you may have to file more applications because one patent is given only for one invention. So that's the first part. That's called unity of invention. I won't go into details. It gives you a list of all the relevant literature, saying these are all the literature which is there. That have you taken into consideration this? And if you haven't, then these are the reasons you may not get a patent, because this is the literature that tells you. Actually, before filing the patent application, you should have done the full search. But PCT also does a search and gives you a search report, helps you. Right? And then it tells you from here, also, it gives you a very classified report, tells you how those particular, publications, what is the value of what is the nature of those publications, how, close those publications are to the invention that you have done. And so taking into consideration all this, it gives you a preliminary opinion on novelty, inventive step, and industrial applicability, which means that from the PCT report, you can do a further assessment of an invention. Would you now like to go and file this in other parts of the world or not? And if you think you shouldn't, then you will take a decision, I will not file this in other parts. Right? So you go through all that assessment. Mind you, patent filing, just simply filing a patent does not end. Filing a patent is only the beginning of the process. It's like the child is born. And only, just after the birth of the child, it has to grow, it has to be nurtured, it has to be taken care of. Only then it will become a man worthy of helping the society. That's how a patent application should be looked at out there. Now, what I will do is, I will now, I've already explained to you all this. I will just take two simple case studies before I end. And here is the case study which I'm giving you of what is known as this company. It's called 4W, Image. It's a small company. What is the history of this company? That they have looked at market opportunity. You see these huge, big hoardings, and also, advertisements on the walls and other places. Now, what this company did was very simple. It studied, all these products. And having studied these products, it says, look, how do conventional image transfer technology is done on walls, on big hoardings, etc., etc. And they realized very, very interestingly, they realized that when these big, the present day means when they were getting into the system, they said, look, what these people do is they have to put the product on the substrate, on the wall, and then they have to use a hot gun, to transfer the image onto the substrate. They said, oh, that's so difficult. Can I find a simpler method of doing it? This is what this small group of inventors thought about. And mind you, this is actually a startup under the startup scheme of the government of India. This small group. I've worked very closely with them, so I'm giving you this example. So what they said is, instead of using a hot gun and heat to transfer the image onto the surface, can I simply use water at room temperature? In which case I can only use a sponge and transfer the image permanently onto the substrate. Beautiful thinking. I don't need equipment, I don't need heat, I don't need anything. See the fantastic thinking of this young Indian entrepreneur. So they looked at it. So what did they do? So they then did extensive literature search. They did a complete landscaping of patents. We helped them out. How to do the landscaping? We looked at all the literature and then found, oh, what you're saying in terms of a thought process is not there anywhere in the world. So can they create a product of that type? So they did it. And having done it, what did we do? We first filed a patent application in India. Then what did we do? We filed that particular patent application, we filed a PCT within 12 months of filing the patent application in India. And then, before I go into that, see, you can see this part. Here, everything is being done to transfer. The image is being done with a hot gun. Here, the transfer of image is done with water. How fantastic. Now imagine the potential of something like this, huge. So you can see that what they did was scan image. They registered, see, we filed the trademark for them. We filed the patent application in India for them. And under the startup scheme of the government of India, they got the patent very quickly in India. And we simultaneously filed the patent in other parts of the world and through the PCT route. And then they got patent in USA, Japan, China, Australia, New Zealand, South Korea, Macau, and other countries. Now, what is the advantage of this? Now you can see, having filed these patents in other parts of the world, having assessed the relevance of these, today, this company, Can Image Media Tech, this company today is negotiating deals in different parts of the world for this technology and this product. Now imagine a small startup in India which filed a patent application in India, then went through the PCT route, doing all these serious assessments that we talked about. A is a leader in this particular field, a startup, mind you. And this is what Government of India has done. Government of India has created a facilitating platform for young entrepreneurs to come forth and do these. So I would urge you people to think about all these things and really find out the appropriate people who can help you out to really take these things further. So you can see this. The technology is so good. See the quality of image right on a wall, which is, completely uneven. Otherwise, using the normal technology, you would have to, do very sophisticated and very expensive. And here they have come out with technologies of this type, which is done so simply and easily. So this is example number one. And my last example, which I want to give you in today's talk, after which we can have questions and answers, is, for example, that was of a small entrepreneur. Here is a company, a drug company in India. What did it do? Again, to create the strategy. What is the strategy? It first selected certain drug substances. They did a search, found out that for these drug substances and for the formulations of that, there are patents which are expiring or is going to nearly expire in certain selected countries. So patent search became important. Then, having created a patent landscape, they said, okay, these particular patents belong to some very big companies. and those patents are about to expire. So these big companies would like to extend the brand. So they're looking for formulations. They're also working on it. So what did this company do? This company then designed formulations which are non-infringing and patent. They created a patent strategy for those formulations, filed patents in India, then filed PCT application, and then in the national phase, as I said, after 30, 31 months, filed these particular patent applications in various countries of business interests around the world. Got regulatory clearances, and then negotiated deals with various companies simply to sell their patents off. And they sold those patents off in a very strategic manner. In fact, I was involved in all those transactions out there. So once they sold those patents, they even went and said, okay, we have sold you the patents. What about the know-how? Are you interested in the know-how? So they sold the know-how, they sold the patent. And then after that, this foreign company told these people, can you manufacture it for us? So they gave them the license back. So you can see the strategy that's created. And all this was possible only because, as I told you, that when you go into the, for example, why was it possible? It was only possible because the right questions were asked right in the beginning, and a complete framework of questions and answers which were put, a strategy was created for the foreign filings, and we knew exactly why we want to do certain things. So I will stop at this stage and leave the floor open for questions.